Once you kindly, if my lord, may I want to mention one matter, my lord. Well, I filed a suit for declaration injunction.
Upgradation.
Upgradation. Only the difficulty matter was item 16. Then, my lord, now it's come to 88856, my lord. My urgency is that they are going to in a car parking space without any authority. They are going to install a.
All right, hand over the slip. Have you mentioned the?
Yes.
You have indicated the urgency.
Yes.
My lord,
And-
my lord,
Lordship, kindly consider this.
Yes.
Several
May I, your lordship,
given this urgency, my lord.
Yes.
may I, my lordship, leave my lord to mention a very urgent matter. My lord, the interim order was passed ex parte on August 4th. We filed the civil division last Thursday. My lord, by this order, my lord, I am a public listed company. All the resolution passed in the annual general meeting have been stayed, and all my board of members of the board have been directed to be personally present on September 3. And ex parte order without hearing me. And all the resolution passed in the meeting of the annual general meeting of the public listed company has been stayed of the Alipur learned first judge. My lord, may it appear, my lord, as early as possible.
All right, hand over.
my lord, on account of
Yes.
Order a copy. Lagi.
My
My lord.
property is almost encroached by the opposite party respondent. So I am going to appeal.
my lord,
My lord, may I be permitted to mention item number 83 for extension of interim order, my lord? The interim order got expired.
Jalpaiguri Circuit Bench for filing of a civil revision and a transfer petition. So I hence pray for my lord's kind permission and leave to file it before the principal bench.
Why?
My lord, in Jalpaiguri, my case is pending in Jalpaiguri District Court.
Yeah.
So the problem is the defendants have a huge influence in the area, and I'm
Please file there. Thereafter, if it is transferred, it will be seen. Now the Jalpaiguri bench is there. Yes.
My lord, may I be permitted to mention one matter, my lord?
Yes.
For
Mr.
extension of interim order, my lord, item number 84, interim order got expired on 10th. I have filed the application within the time, my lord, which is pending. My lord, this is the demolition matter, my lord. We are suffering a demolition proceeding.
Item number 84.
83, my lord, 83.
83 টা কালকে তুমি মেনশন দিয়ে এই এক্সটেনশন অফ ইন্টারিম
Grateful, my lord.
1830 project is for upgradation. My lord,
প্লিজ হ্যান্ড ওভার দ্য স্লিপ
the next date is like 28th of August. My lord.
হ্যান্ড ওভার দ্য স্লিপ
May I mention one? My lord, the matter is running in the monthly item number 35, my lord. Because urgency is that the REIT is going to be executed, my lord. If the REIT is executed, my revision will be in fact just
item number 35 this is the first matter I think which will be taken up today.
Monthly is item number 35, my lord.
Yes,
My lord.
from 23 it will be taken up
My lord,
today itself. Please wait. Yes.
may I I mention another matter, ma'am. This matter in respect of BNSS, whether the appeal will lie or not. Item number 132. So, my lord, the appeal will lie. My lord, last order of the observations, the appeal will lie. So, I want to take back the revisions with the liberty to file the appeal. So, kindly fix it on to be mentioned tomorrow.
Item number
132, my lord.
132 টা কালকে টু মেনশনে দিয়ে দিন for
Monthly, আজকে list to 132.
My lord, I have a very small case, my lord. I am not being able to see my son for the last 2 years, my lord.
hand over the
My lord.
May I be
Obliged,
to
Lord.
mention matter, the expeditious hearing matter is for 2 long years before the trial course.
hand over the
And-
My lord, I am mentioning one matter, my lord. This matter was fixed trial court on 14th. That was fixed for evidence. My lord, I placed the monthly list and paid for an adjournment.
what is the impugned order?
Impugned
What order you have challenged?
impugned order, substitution has not been allowed. My cancer patient wife, he transferred hard share in favor of his husband. That
What
has
is
been
the
resolved.
application which was filed which was disposed of by the impugned order? What is the impugned order?
Impugned order is I prayed for substitution in place of deceased. Wife, husband's name will be substituted. That has been rejected.
All right, hand over the
31st is the fix for final last time argument.
My lord, I mentioned this matter on Friday. My lord asked me to come back on Monday. My lord, I have, my lord, got a decree, eviction decree. My lord, tested up to the Honorable Supreme Court. Now, my lord, execution is pending. Honorable Supreme Court has directed, my lord, the execution matter is to be disposed of within 4 months. Almost 3 months, my lord, has lapsed. Now, the judgment debtor himself, my lord, has taken out an application under section 47, saying that, my lord, there is a suit pending where he is challenging my lord, ownership of the property. And so, my lord, the execution cannot proceed. My lord, from that, my lord, we filed a revisional application. My lord, my lord, granted them liberty to pray for adjournment 1 day. My lord, they have exhausted. Mr. Shakushen was appearing. Now, every day showing that order, my lord, adjournment is being granted. And
It's appearing in the supplementary list.
87.
All right.
My lord, very similar
My lord,
facts.
kindly, my lord, upgrade, my lord, this matter.
My lord, it's item 983 of the monthly list of August. My lord, and senior friend is appearing, my lord, on the other side. My lord, this is a civil revision. We are the award holder. My lord, we are the award holder. Revision has been filed where there's an undertaking by both the parties that will pray for an adjournment in the execution proceedings. We have filed an execution proceedings for 1 day. That's, my lord, in May 2026. It's over. You know, this matter is pending, my lord. We can't proceed with the execution. The point is very short, but may I only pray for if it is upgraded, taken up any day, my lord.
Please hand over the slip mentioning
My
that.
lord, this is, my lord, rejection of amendment. Against that, I have come. My lord, 19th is the date, my lord, for evidence. My lord, if your lordship, my lord, this is appearing in the monthly list and 1186. So if it is
Yes, hand over
possible,
the slip.
There is a new motion, my lord, not running in the list. My lord, next date is on the 1st of September. My lord, on 2 occasions, I have prayed for time in the court. My lord, now, my lord, on 3rd occasion, court is reluctant. Now, my lord, the urgency is, my lord, I tell your lordship, my lord, any day prior to 1st, my lord, a report of an expert witness, my lord, has been accepted where the report is unsigned by the expert, and the expert who done the report, my lord, he is not been put on dock. My lord, a third party is coming to depose on behalf of the expert. My lord, that report is been tendered and exhibited and taken on record.
Hand over.
My lord, kindly, my lord.
To mention, my lord, it's for
item number 88 of the combined list for 29th August. The cost of the police service.
All right. Hand over
may I
the
be permitted to mention, my lordship, this is for inclusion, my lordship. This is a restoration application, my lord. The suit is fixed tomorrow, your lordship.
restoration application.
Lordship.
Why were you not present when the matter was taken up?
The advocate,
You have missed one chance. You have missed.
my lord, my 717 has been rejected. It's
Cannot be held. You have missed one chance. That is why it was dismissed for default.
Tomorrow is the next date, your lordship.
Many matters are there who have not got one chance. You have got one chance. Yes.
Anything can be
Yes,
done.
Mr. Banerjee.
My lord, I have 4 analogous matters. My lord, I will be praying for upgradation. Advocate on record, my lord, he has, my lord, got stuck in, my lord, the traffic congestion. My lord, may I just hand over the slips once, my lord, he reaches.
One more, my lord, mentioning, my lord, this is upgradation. My lord, only thing, my lord, shares are admitted in a partition suit. My lord, the commissioner, my lord, who was appointed, my lord, he visits the locality suit property. My lord, he inspects, my lord, up to 1st floor, but doesn't go up to the 2nd and 3rd floor, saying that I am not being directed to go to 1st floor. My lord, at that juncture, revision was admitted. Now, my lord, only point is that he be permitted to go to 1st floor when parties are saying it's a 2-storied building, my lord. In that is why, my lord, there was a stay granted, my lord, shares admitted, only that commissioner will file a report. My lord, we are at dearth of accommodation. My lord, unless this is done, my lord, we are at a position not to, my lord, divide the property by metes and bounds. And my lord, furthermore, my lord, an injunction order, my lord, challenged.
Many matters, Mr.
My lord,
Chatterjee.
these are now, my lord, trial courts are no more granting time.
Please decide according to the priority that will be taken. ওনাকে সবকটা স্লিপ ওনার কটা দিয়ে দিন।
May I be permitted to mention, my lord, one review petition was pleased to heart by the then Honorable Chief Justice Sujoy Pal and my lord. And my lord, now the matter has been assigned before my lord and Honorable Justice Om Narayan Rai.
Lordship, I had mentioned on Friday, Lordship had directed to come yesterday, today. If your Lordship, because this is this matter where the power of attorney was not there, Lordship had heard this. The next date is on 20th. Lordship, may kindly.
All right, hand over the slip. Hand over the slip.
Sir, বলছি স্যার পিটিশনার ইন পার্সন একটা ম্যাটার এখানে অ্যাসাইন্ড হয়েছে, চিফ জাস্টিস অ্যাসাইন করেছেন, আপনি অলরেডি 4th অগাস্টে ম্যাটারটা নিয়েছিলেন, তারপরে লোয়ার কোর্টের ডেট দেখে আপনি 12th অগাস্টে ম্যাটারটা ফিক্সড করেছিলেন, কিন্তু আপনি যেহেতু অ্যাভেলেবেল ছিলেন না 12th অগাস্টে, ম্যাটারটা স্যার হিয়ারিং হয়নি, লোয়ার কোর্ট আবার 21st ডেট ফিক্সড করেছে। স্যার কাইন্ডলি যদি ওটা দিয়ে দেন যদি।
Item number 16 there is a interim order extension petition.
Extension of interim order. ওটা এটাকে extension of interim order দিয়ে দিন। Extension of interim orders, please hand over the slip. Extension of interim order, please hand over the slip.
My lord, I have another mentioning of for upgradation. I have mentioned the ground of urgency.
Lordship, may I be permitted to mention a matter?
Yes.
Lordship, this is the matter where from 5th May, Lordship, the next date has been kept as 8 October.
And the irony is that, Lordship, this is in regard to an unauthorized Durga Puja. Lordship, the trial court has failed
What do
to
you want,
frame the
upgradation?
issue. Lordship, upgradation.
I am praying for leave, your lordship. The petitioner filed one application of guardianship and Wards Act, your lordship, and the next date is fixed for evidence on 21st of this month. But in the meantime, your lordship, I have also filed an application for visitation right. Keeping that pending, your lordship, the next date is fixed for evidence. In spite of this, the application is pending. So kindly take up the leave, your lordship.
My lord, may I please mention one matter, my lord? The amendment, against the amendment, 24th is the date. 24th August is the date, my lord, PWD one already examined. At the juncture, my lord, they allowed the amendment application.
Hand over the slip.
One matter.
I wanted to mention one more matter for application. My award has been received. Next date is tomorrow.
Hand over the slip.
My lord, may we permitted to mention a matter? The interim order, my lord, is expiring today.
Please hand over the slip, I've said.
My lord,
Hand over the slip.
But in 142, I am there. But I have in 142, I am for the
Item number
opposite.
148.
Yes.
Lordship, item number 137 of the monthly list. Similar matter between the same party, same subject matter, analogous. Your Lordship was pleased to release it on personal grounds because of appearance of some of the parties. Attach the order by which Your Lordship had released the matter.
my lord,
August monthly list. We have the interim order.
What do you want, upgradation?
For application.
Please hand over the slip.
Maybe.
my lord,
Applications, please hand over the
May I
slip.
be permitted to mention a matter, my lord? My lord, I am the decree holder as well as the opposite party in this matter, my lord. Now, my lord, eviction arises out of the eviction suit. The trial court has, my lord, the appellate court has stayed the execution proceeding on the condition that the occupational charges has to be paid. Now, my lord, the payment has not yet been done, my lord. Challenging such order, my lord, has the petitioner has come up before your lordship. So, my lord, I am only praying for upgradation of this matter if this could be taken up as early as possible.
hand
Your
over the
lordship.
Maybe permitted to
Grateful,
mention
my lord.
Item number 148 of the daily list, Lordship. My lord, the visitation right was sought for on 22nd of August 2026 this month. But the trial court has fixed on 22nd of September 2026. My lord has heard the matter and fixed it on 14 months.
Yes, hand over the slip.
Grateful.
Motion, Lordship, can you include of the list motion stage?
Upgradation of item number 515 of the monthly list. DRT has by an order refused
Hand over the slip. You have indicated the charges.
My lord,
disposal. Expeditious disposal.
my lord, may I,
for inclusion, my lord, a contempt application, my lord.
Contempt.
my lord, may I, Lordship, kindly to mention.
Upgradation. Hand over the
My
slip.
lord, may I, Lordship, kindly to mention one matter? May I mention? My lord, 1183 of the combined list, it was, my lord, released it on personal ground, but again it is appearing. Lordship, kindly see.
I'm mentioning item number 46 of the
Release
monthly list.
could
The matter
attain
is
which
fixed
will
on
make
19th of
our
this month,
taken.
lordship. It may be kindly taken.
Taken away in order.
Lord, may I mention item?
Yes.
May I mention item number 2119 of the monthly list? I pray for inclusion in the daily list, my lord.
Upgradation.
Yes, my lord.
Hand over the slip.
My lord, I am mentioning a matter, my lord.
My lord.
My lord, observation of item number 2110. It is a contested application, but my lord,
Contempt.
but contested, my lord.
Oh, contested
But
application.
one
Mr. Rai,
difficulty-
please.
One difficulty is, my lord, is I have filed an application for repairing of a tile sheeted roof. Roof is in dangerous condition, hanging, my lord, practically. Within a few days, if it is repaired, the petition will highly prejudiced. Maybe followed up.
Hand over the slip.
My lord, kind leave to mention a matter. My lord, just to leave to file a review of my lord's order.
Why leave?
Without certified copy.
Why without certified copy?
Because my lord, the state wants to file a review, my lord, as because the instruction.
No, why without the certified copy?
We had applied for it.
When have you applied for the certified copy?
After getting instruction, my lord, we have applied on 13th August, my lord.
So then you have to wait.
My lord, they have availed a contempt which is supposed to
Maybe.
come up.
Maybe.
My lord, one contempt matter. My lord, one contempt matter assigned before your lordship by Honorable Chief Justice, your lordship and Justice Patronai, my lord. This matter is pending since 2022. Formal Chief Justice Shivanganam already passed the order.
It has been assigned.
Yes, my lord.
Please hand over the slip.
My lord, it is
Assigned with justice.
Patronai, my lord. Justice Bivas Patronai.
ওটা দেখে নিন।
My lord,
This it,
the
I am
respondent
giving
of
the
the
slip.
execution file, please
Let the
update this matter.
Please hand over the slip. Yes, Mr.
Because this particular matter, last occasion I also mentioned because this is the matter where my lord two district judges certified copy
Yes,
of
what is the item number? Monthly list.
monthly list, my lord, it was fixed.
What is the item number?
1316.
1316. Hand over the slip.
Lord, may I permit to mention?
Kindly, my lord, problem is, my lord, interim order though back it is showing that pendency of the matter, I am not getting any help.
Who is appearing for the other side?
Other side, on the last occasion, I give the evening,
এটাকে কালকে টু বি মেনশনটা দিয়ে দিন।
I am
Yes.
giving the.
May I permit to mention one contempt matter, my lord?
Hand over the slip. I said, please hand over the slip.
And may I permit to mention my matter for upgradation, my lord, expeditious disposal.
Hand over the slip.
My lord, may I mention?
May I seek an indulgence from your lordship? My lord, I had mentioned the matter number 1895. My lord, there is a very situation of my advocate on spot. The applicant is already employing an interim order. If the lordship is kindly needs to pick up the matter. As per your lordship.
You have seen the so many mentioning. I have to consider all the slips.
I absolutely appreciate your lordship.
Yes.
লর্ডশিপ আমার আমার কেসটা আছে আইটেম নাম্বার 187 মান্থলি ডিসচার্জ কিন্তু আমি আজকে যে নিউ মোশন আছে আমাদের যে আরো অন্য প্রসিডিং গুলো বাকি রয়েছে এই কারণেই এটা মানে ফিক্স যেহেতু হচ্ছে না তাহলে ওই প্রসিডিং গুলো বাকি রয়েছে
স্লিপটা হ্যান্ড ওভার করুন। স্লিপটা দিয়ে দিন।
26 27 28 ওখানে ফিক্সড আছে
ঠিক আছে।
Extension of indicator.
Extension of when it is expiring. Have you indicated that? Please indicate when it is expiring.
Lordship, may I permit to mentioning,
My lord, may I?
Lordship, may I permit to mention item number one.
I think he is senior to you, madam.
Sorry.
Item
Started mentioning, yes.
Item number 55 for lordship's list, my lord. My lord, the order passed. by the-
Monthly list.
No, daily list. The order passed by the under the POSH Act has been challenged, my lord. 30 days expires today, my lord. I'll be out of service from today only, my lord. I mentioned this on Friday, my lord. My lord asked me to come back today.
Item number 15.
55.
55. Let me see how far I can proceed.
Or else, then I'll come back at 3 and mention again.
If not taken up, please come back at 3. Yes.
My lord, I am permitted to mention, my lord, item number, see, monthly list, my lord, 1343 and 134, similar matter, my lord.
Please hand over the
Item number 1818, well, I have filed my 7.
upgradation.
Upgradation.
Hand over the
Lordship for inclusion, lordship.
motion.
Motion.
Yes, call the list.
Lordship for upgradation,
my lord. Item number 1244 of the monthly compilation.
Upgradation.
Yes, my lord.
And
Only one pair, my lord. Item number 50 of the combined monthly list, my lord. Here is the wife is not allowed the husband to see.
what do you want? Upgradation.
Yes, because
Yes.
child, only visitation right of the child, my lord.
Please hand over the slip mentioning the urgency. Yes, call the list.
আমি দুটো স্লিপ পরে দিতেছি আপনাকে টাইপ করে
One.
But have a look at your lordship.
Why to be mentioned?
Lord, the mediation has failed. The Honorable Single Judge, Miller, Justice Sarkar had sent the matter to mediation and then said, Miller, that if the mediation doesn't work out, then the matter, Miller, will be heard by the revisional court. Miller, I had filed an application for recalling of the order of mediation because I knew, Miller, the mediation will never work with my adversary.
Recalling
That
now
has
the
been disposed of.
mediation has failed.
Been disposed of. Saying that if the mediation doesn't work, then, Miller, the revisional court will hear out. Miller, I have two problems here. One problem is my child, Milord, suffers from ADHD. So he needs medical help. Milord, I stay, Milord.
Child is with whom?
With the mother. Mother appears, Milord.
You are the father.
Person. I'm the father. But the mother, Milord, appears in person. And because she appears in person, Milord, what happens is the matter is not heard. And although though she's not here, Milord, I should not make these submissions. But the problem is the judge has recorded, if your lordship sees, my lord Justice Sarkar, that people should understand co-parenting. I am on that.
No, previously, a learned advocate used to appear, Mr.
No.
Rajdeep Bhattacharya.
That after that she's been appearing in person. Even on the last occasion, lordship,
Chatterjee, have you notified her?
we had mailed, we had given everything. What I said, pray before your lordship is fixes a date tomorrow or day after, my lord, as per my lord's convenience, because this is very urgent for the child.
Mr. Chatterjee, unless you serve a notice.
I will. That's what I'm saying. I will.
Serve a notice. I'm keeping on the same heading.
My
In
lord.
her presence, otherwise, you know,
So,
there might be difficulty.
I am praying for that. I am praying for that only. Say on Wednesday or Thursday, if it, not Thursday, Wednesday. back in hospital.
Mr. Chatterjee, Learned Senior Advocate appearing for the petition.
Lordship, this matter has been filed under civil revision, but it will be filed under criminal revision, Your Lordship. 125 CRPC matter.
On the prayer of the
Petitioner, my lord had passed an order, an interim order, which is expiring today. This is the interim order, my lord. It has been extended from time to time. And my lord, on the last occasion, that is on the 24th of July, Honorable Justice Rai was taking the determination, and he had directed upon us to serve a copy of the order to the respondent's advocate, and we have done so. This is the affidavit of service, my lord.
The interim order is valid till which date?
Till today, my lord. It's expiring today, my lord. This is the interim order.
The interim order, the
My item number 5 to 7 was there. 5, 6, and 7.
5, 6, 7. Yes.
The petitioner, my lord, the interim order expired sometimes in April, my lord. I have since I had no.
What is the application for?
Application, my lord.
For
by virtue
extension of
the
interim order?
my lord, my lord.
Application is for extension of interim order.
Yes, application is for extension of interim order, and main application is for, my lord, the stay has been was rejected by the learned additional district judge because they were proceeding with the execution case, my lord. I have prayed for stay of the execution case, that has been rejected. But my lord, I have one submission. Between the same parties, my lord, 3 applications have been filed. Another application is appearing in your lordship's list, that is for expeditious disposal of the appeal. Subsequently, my lord, appeal is 12 years old. Twice the appeal was dismissed. My lord, on some occasions, my lord, I appeared before the learned additional district judge, tried my level best so that the hearing of the appeal be started. Since that has not been done, my lord, I have filed one application for transfer of the appeal. Initially, my lord, opposite party said he will file my lord application written objection. Subsequently, my lord, he conceded. He also wanted transfer because, my lord, nothing is happening. The transfer petition has been rejected. Challenging that order, another application has been filed before my lord. On last Monday, I have mentioned that matter for my lord upgradation. Today, my lord, I have seen the matter has been sent to the court of the Honorable Justice Rai Chattopadhyay. If you, since my lord, out of 3 matters, 2 matters are appearing before your lordship. If your lordship kindly brings that matter.
I cannot bring that, Mr. Rai. How can I bring that?
No, for the sake of my lord.
I cannot bring that. You have to take steps for that, Mr. Rai. How can I bring that? Can I bring that? You have to take steps.
My lord, I am taking step, my lord. Then, my
With
lord.
regard to this, you have filed an application, Mr. Rai, then I'm keeping it tomorrow because today we have taken a resolution because you are
Nobody is appearing, my lord, but my lord can take up.
tomorrow because today you have
my lord.
not today করে রেখে দিন শুধু আর কিছু করার দরকার নেই। Yes, next.
I'm getting.
Thank your lordship. For the petitioner, on the last occasion of Friday, your lordship had asked me to serve upon the advocate who is, but when I called the advocate who is appearing, is arguing the matter before the small causes court, had not come to court on that date. But I had mailed the advocate as well as I had taken instruction from him regarding.
Sara, I'm keeping it for tomorrow because today there is a resolution. I'm making it only not
That
today.
is not an issue. Only issue is that it is expiring today.
Expiring today?
Today. If your lordship does not ask for an application, then it's fine. I have no objection because the date is fixed on 1st of September.
Date is fixed on 1st of September.
1st of September.
Then tomorrow I will be taking up.
No issue.
আচ্ছা এটা order.
Item number
10. Which item?
Next 11.
Passed over. Next.
Number 11, I'm asking for the petitioner. Defendant is the petitioner, my lord, in a suit. My lord, for eviction, my lord, what happens? Can he turns to the impugn order for once? Turns to the impugn order, my lord, dated 22nd September 2025.
Dated?
22nd September 2025.
22nd September 2025. Yes.
Now, my lord, the plaintiffs, my lord, file a petition to take off the suit from the peremptory board and also files a petition to accept the report of the commissioner, my lord, filed on such and such, and petition for recall dated such and such. Take off the petition is first taken up for hearing. Petition is considered and allowed. Let the suit be taken off from PH. My lord, no reason on that part. Now the petition for recalling is taken up for hearing. It appears from the record by order dated 7/7/25, recalled by order number 82, whereby Mr. Nojrul Islam Chaudhary was appointed as survey past investigation commissioner, holding that the plaintiff had deliberately failed to take any steps for appointment of new commissioner at the death of Mr. Nojrul Islam Chaudhary. However, it appears from the record that by order dated such and such, this court has already appointed Mr. Keshav Chandra Ghoshal as new investigation commissioner. In the above, this court order number is required to be recalled by applying provision of section 151. The order dated such and such is recalled. It appears from the learned investigation commissioner, Mr. Keshav Chandra, has already filed his report on 14/7/2025, and further the plaintiff has filed a petition praying for acceptance of the said report. In view of the above backdrop, the petition is considered and the report of the investigation commissioner is hereby provisionally accepted. Now, my lord, after accepting this provisionally, my lord, he puts the matter in, my lord, PH board. My lord, I have a right to, my lord, file an objection. My lord, kindly recalls, my lord, initially Nojrul Islam was appointed as an investigation commissioner. My lord, I don't know why. My lord, in a suit for eviction, my lord.
That question cannot be taken.
Now, my lord, on the if it is recalled, my lord, the appointment is recalled, my lord, by a subsequent order, my lord, then Keshav Chandra could not have, my lord, go for a commission work. So therefore, my lord, now, my lord, Keshav Chandra, without the writ being there, my lord, goes, my lord, and prepares a report.
Where is the report?
My lord, that is being accepted provisionally.
No. The report was filed earlier.
No. Kindly see his commission report filed on this initially, my lord, appointed in 2019. My lord, and the recall order, my lord will find at page 41. Order dated
By an
7th.
order dated 84, dated 20th of November. This court has already appointed Keshav Ghoshal as the new advocate commissioner.
Yes, my lord, therefore, my lord, initially the order was kindly takes up the previous order at page 41.
Yes.
My lord will find order number 82 is hereby recalled. Appointment is being recalled.
Yes.
So, my lord, after recalling this appointment, my lord, I have no chance, my lord, to participate there. Now, my lord, Keshav Chandra, my lord, court, my lord, it was not apprised to court, my lord, court appoints somebody. Now, my lord, court recalls this appointment. My lord, I do not get a chance to, my lord, object to the commissioner's report. Court provisionally accepts the report.
Mr. Chatterjee,
And my lord,
the
fixes
earlier
for
commissioner had expired.
expired. So,
So a new commissioner has been appointed.
my lord, new commissioner appointed, my lord, very well, my lord, if he is appointed, my lord, I should be given a chance to, my lord, to put an objection to that. My lord, it cannot be provisionally accepted. And my lord,
What objection you have?
my lord, he might have, my lord, not done, my lord, something properly, my lord, I should bring that
That's
on record.
against the report. What against the appointment?
Now, my lord, that appointment, my lord, I must say, my lord, in a suit for a local investigation commissioner.
Only Mr. Chatterjee, one person has expired. In his place, another person
No,
has been
if
appointed.
today,
So the application was allowed earlier. So you cannot question the new commissioner being appointed. Only that there has been a substitution of a new commissioner in place of the earlier commissioner who has expired.
Now, my lord, only thing, my lord, in a suit for eviction, my lord, under order 26 rule 9.
That's now, you cannot question that now.
My lord,
You cannot question that now.
In revisional jurisdiction, my lord has posed that question to my lord, in other matter, my lord can look into that.
That is a different matter. This is a different matter.
Now,
it's suo motu power. If you say it's court whether to exercise or not, that the court will consider. It's not a fit case for exercising.
Now, my lord, to this, my lord, if provisionally accept, my lord, this provisional acceptance and my lord putting in evidence, my lord, without allowing me to put an objection.
Strategy, order 26, rule 10, sub rule 2 says that. Please see order 26,
That's
rule 10,
exactly, my
sub rule
lord,
2.
that's exactly, my lord, my point.
So
If it is 26,
it's an evidence in the suit forms part of the record.
Then, my lord, then
the question of further acceptance. Only thing you have a right to cross-examine. I leave you open to apply before the learned trial judge to
then, my lord, allow me to put my objection without an objection, my lord, today. If I take the, my lord, commissioner, my lord, on dock, my lord, then I will be posed with the question, my lord, there is no objection on record as of date. My lord, then, my lord, if that be so, my lord, my
When this
cross-examination.
commission work was held?
My lord, he files a report on 14/7. My lord, there is no explanation in the order.
14/7?
2025, he commission report filed on 14/7. I mean, the impugn order passes on September.
Yes. Well, why are we challenging this after a long time?
No, Lord, this was কবে file করেছো? Revision
5th of August.
5th of August.
These are new motions, Mr. Chatterjee.
Yes, new motion.
The day which you mentioned.
I know, Miller. This is the
So
now the suit was taken off from PH board.
No reasons for the delay has been shown.
Miller, kindly appreciate.
1 year
if
delay,
today,
Mr. Chatterjee.
If today, Miller, my delay, Miller, my lord knows. Miller, revisional jurisdiction, though there is no period of limitation, but certainly, Miller, in ordinate delay, Miller has to be, Miller.
Delay and latches, it's the court which will.
Miller, definitely, but Miller, if it is glaring at the.
Please show me what is the explanation for 1 year delay. You are only trying to delay this suit.
No, my lord.
Yes.
এটা কোথায় পাবো?
No explanation, Mr. Chatterjee.
Lord, there is.
Yes. So gone.
In that count, Lord, kindly appreciate, Lord, today if there is no objection, my Lord is permitting me to cross-examine. Lord, allow me to put my objection, Lord, that's it. Lord, that is only thing, Lord, that would be, Lord, protecting my
Where it says to file objection. Please show me from the statute. Yes, Mr. Chatterjee, you have read that. Yes, I will give you only that liberty. Asun, this application under Because you have taken 1 year time to approach this court after the impugned order has been passed.
No, my lord, it's an advice. My lord,
Yes, next.
But I think 12, my lord, Mr. Onimes Pal is appearing, my lord. He is on medical ground, my lord. I am praying for not today. Only not.
Please start. Yes.
I am not an advocate record. My lord, Onimes Pal is the advocate record. But he has not, my lord, come today. My lord.
Who has not come?
My lord, due to medical ground. Due to his illness.
Please use the microphone.
Due to his illness, my lord.
Who has not come?
My lord, Onimes Pal. Who is the advocate record? I think so, my lord.
Not today.
Only not.
Yes.
Lordship, in this matter, I am praying for 1 week accommodation, Lordship. 1 week accommodation, Lordship.
Please start.
Lordship, actually, today I received this brief, Lordship. Today I received this brief, Lordship.
That's not a ground. Yes, please start.
Lordship, after receiving the brief, Lordship, I perused the brief, and Lordship, against the order passed in the execution proceeding, wide order dated 21/7/2026, this present revisional application has been filed. In that event, I humbly draw your Lordship's kind attention on the impugned order. The particular point is that which is being assailed in this revisional application, that the evidence of decree holder was not done, and for what reason the evidence of decree holder was not done, we don't know. But Lordship, evidence of decree holder was not done, and the
execution decree holder will depose as to what fact? To prove what?
It is also a fact, Lordship, that I searched several judgments. In this judgment, it is written that it is not indispensable. It is not indispensable. But Lordship, kindly give me an opportunity to further research work, to continue the further research work,
This
Lordship.
application under Article 227 of the
Next is also, Lordship, the same matter, and arising out of separate execution.
Same order, next. শুধু ওই সুটের নাম্বার টাম্বারগুলো চেঞ্জ হবে, ওটা দেখে নেবেন। টাইটেল এক্সিবিশন কেস নাম্বার টাম্বার। Yes,
Mr. Mehboob Ahmed is appear on this matter.
yes.
This is the expeditious disposal of the suit.
Special disposal of the suit. Suit is at what stage? Suit is at what stage? Cross examination with DW1.
Yes, cross.
What is the next date fixed?
But Lordship, the previously one revisional application was filed in the 2025, which was dismissed, which was disposed on the 5/5/2025. And thereof the opposite party herein have filed a CAN 1 application, and during the advantage of the pendency of the CAN 1 application review, they taking adjournment in the court below. Lordship, kindly the CAN 1 application was heard, this revisional application, kindly and we serve the note, tag the
What is the CAN 1?
the review of the said order of 5/5/2025.
So there is no stay order. Then this application under article.
Defendants are the petitioner before the Lordship. By the impugned order, my application for recalling of the order vacating, whereby my lord suit has been directed to be proceeded with expert.
You have become specialist in these matters, Mr. Mahato.
Has been directed to be expedited, and I have not filed the document according to provision of Order 13, Rule 1 of the Code of Civil. I have not filed any document in support of my case. Therefore, the court has directed to be proceeded with expertise. My evidence goes, my oral evidence goes, my right for cross-examine goes, everything will matter. The suit has been right.
Cross-examination, you have a right. I clarify that.
Also right to adduce my oral evidence.
You can proceed with the suit from this stage as it is, not going back, unless you show good cause for your non-appearance.
I have not appeared, not that. I did not file any document in support of my case, according to Order 13, Rule 1.
Where is the order by which it was
Yes.
suit was fixed for
Yes.
expert hearing? What is the order?
My lord, the order dated 19th of May 2026. No, my lord, 18th of February 2025, last page, man.
15th of?
18th of February 2025.
Where is that order?
Last page.
Last page.
Certified copy, last page. I have challenged that order also.
18th of February.
And today is fixed for compliance under Order 13, Rule 1 of this PC by the defendants with cost of rupees 3,000 per provided. Subsequent, my last paragraph, but as the defendant did not comply with the order of this court dated such and such, this court of the opinion proceed with the suit expert.
Where are these two orders, Mr. Mahato?
Hello?
10th of September 2024 and 18th of January 2025. Where are those orders?
Is that I have entire order sheet is with me.
Oh, you have annexed that?
No. My certified copy is with me, my lord. No, 18 না এখানে যে দুটো অর্ডার 14th March 2023 in March 2. My first order is 10th of September 2024.
Where is that?
Yes. Okay. My lord, this is. এটা একটু দিন না। For direction to proceed with the suit expertise is my lord non-filing of documents according to provision order 13 rule 1 of the code of suit. I may not have my lord any documents in support of my case. But for that reason, it should not be my lord, the court should be proceeded with expertise.
The issue that arises for consideration is whether yes. Next.
I am not on caveat, my lord. I have requested my learned friend to supply me a copy, my lord. My learned advocate on record as an instruction.
My lord, the plaintiff in a suit for declaration that the classification of its account as fraud is illegal. Plaintiff in a suit, the classification of his account as fraud.
Who are you?
I'm the borrower.
No. Plaintiff or
Plaintiff.
Yes.
Interim order sought for. The trial court says your interim relief is in the nature of final relief. Because I seek a stay on that order. Trial court says interim relief is in nature of final relief. Dismisses. I go before the appeal court.
Injunction application dismissed.
Ad interim.
Ad interim refused.
I go before the appellate court. Appellate court says your suit is barred under section 34 of the SARFAESI Act.
Yes.
No.
Why?
SARFAESI Act suit is barred only in respect of measures under section 13.4. 13.4 presupposes noting under 13.2, which presupposes that the account of the borrower has been classified as a non-performing asset. Here, my lord, what the propriety of the classification of the account as a fraud account is under challenge in the suit. No, my lord. My lord will ask me.
Challenge that. Challenge that.
No,
Fight it out in the suit. No interim order.
Kindly visualize. Kindly visualize, my lord. Kindly visualize this, my lord. The issue, my lord, is the bank is a private bank. So my writ does not lie. So I have to move before the suit court. Now, my lord would see the order for once. The order proceeds on twofold grounds, my lord. Now, the my lord, RBI guidelines says there has to be a composition of a committee. The show cause notice has been.
Show me your plaint.
Plaint, yes.
Let me see whether the plaint can be rejected from here.
Yes. Kindly see. Page 304.
Show me the plaint.
Page 304.
304.
And sees my prayers at page 324. The SARFAESI Act has no manner of application whatsoever.
What is the OA which is pending?
OA has been filed by the bank for recovery of its dues. So, Miller, the first is the show cause notice, which is at page 55.
Do you have a SARFAESI Act?
The seasonal, SARFAESI. The bar is in section 34 and 35. Then, Miller,
Mr. Bordon, 20th of August is the date fixed in the miscellaneous appeal.
Miller, kindly seize the
Please serve him a copy. I direct the appellate court to decide the miscellaneous appeal.
Till that time, let them not take any steps. Nothing will happen.
Today we are on 17th. Nothing will happen if you have succeeded till this date.
The appellate court.
Please give a copy.
Yes,
Mr.
we will.
Banerjee, please appear in the miscellaneous appeal. You file your.
My lord, kindly indicate that my lord has not gone into the maintainability of the suit. I find that the suit is barred by law.
Fine, we argue that.
I have not gone into that because I have seen that is that Ashok. By the order impugned. Now, Your response. 18. Yes, yes, Mr. Banerjee.
Your Lordship, kindly give out the order.
Yes.
The last.
Yes, Mr. Banerjee. What is this matter?
Lord, if your Lordship kindly takes up the matter, Lord, at 2 p.m. Just now, Lord, I have come here, Lord, the water logging and Lord, the
2 p.m.
2 p.m. Lord, subject to your Lordship, kind convenient.
All right. 2 p.m.
I'll come back, Lord, at
2 p.m.
I'm to look
Yes.
back.
Yes, next.
Allowed in this matter, my lord, this is my application for the petitioner, and this
Use the microphone.
I'm for the petitioner, my lord. This is my application for expeditious hearing of the matrimonial suit pending before the learned district.
Who are you?
But I'm for the petitioner, my lord, husband.
Husband.
Yes, ma'am.
What is the stage of the matrimonial suit?
My lord, cross-examination of the petitioner is going on. Today is the day.
Cross-examination of the petitioner is going on.
Yes, ma'am.
And any order for alimony?
We are paying the alimony, my lord.
You are paying the alimony.
Yes, ma'am.
Order of alimony passed in this matrimonial suit.
Yes, my lord. Yes, ma'am.
This application under Article 227 of the
As the defendants in the suit below, this is a suit for injunction against alleged unauthorized construction, my lord. I had made an application for stay of all further proceedings in the suit on the ground, my lord, that a similar suit for ejectment concerning the same property between the same parties has been decided by the trial court and is now pending appeal before this honorable court, my lord. Lordship, there are two suits. One is for injunction, that is the present suit, and the other is the ejectment suit. Both the suits, my lord, pertain to the same property between the same parties and involve the same documents.
Please show me the plain.
My lord, the plaint in this suit, my lord, your lordships will find at page 18.
This injunction suit filed by you.
No, my lord, I'm the defendant. In both the suits, my lord, I'm the defendant.
In both the suits, you are the defendant.
Yes, my lord. My lord, what has happened is your lordships will kindly take the schedule, the suit property, my lord, at page 24. Lordships will seize, may I place, my lord? All that vacant space along with 4 rooms as servant quarters.
Where is the suit for eviction plaint?
My lord, the plaint is at page 33, my lord. If- 53. Yes. So the schedule is at page 53, my lord. Here, my lord, the suit property in the injunction suit has been bifurcated into Schedule 1 and Schedule 2. Schedule 1 is the vacant portion, and Schedule 2, my lord, is the servants' quarter and the garages.
This suit for injunction is at what stage?
My lord, we filed a written statement, my lord. It's for finalization of issues. Your lordships will kindly take.
Issues have been framed.
No, my lord, it's been fixed for submission of suggested issues. Your lordships will take page 84. That has the impugned order, my lord. My lord, at page 85, your lordships will see at the bottom, 3rd July 2016.
Page
85, my lord. Your lordships asked the stage of the suit, my lord.
No, I have the certified copy, yes.
Yes, my lord. Page, yes, my lord. At the bottom, your lordships will see order dated 3rd July 2026.
3rd July?
Yes, my lord, lordships does not have.
Yes, 3rd July.
Yes, my lord. My lord, at the bottom, your lordships will see fixed 1st September for bringing a specific order from the High Court. Just above that, my lord, it's for submission of suggested issues. Parties had prayed for an adjournment. My lord, my principal grievance is, my lord, that even though section 10 of the CPC is not satisfied, the court had powers under section 151. And my application was in the interest of justice and to avoid multiplicity of litigation. The ejectment suit, my lord, in a manner of speaking, is larger, whether I'm supposed to be on the suit property or not. And the permanent injunction suit, the injunction suit is a smaller right, my lord, whether I'm allowed to construct or make certain constructions. Their suit, their ejectment suit has been allowed only in part. And my lord, there's an order of stay of the operation of the decree in the ejectment suit by this Honorable High Court, my lord.
That is stay of operation of the judgment and decree is from executing.
Yes, my lord, but my lord,
that does not mean that the decree evaporates.
No, my lord, I'm not going that far, my lords. All I'm saying is that this issue is pending. The evidence in both the suits are common. They all pertain to 3 central documents, my lord. Those are exhibits in the ejectment suit. My lords, I'll have to go through the entire process of trial, bringing in the witnesses, presenting the same documents, etc. My lord, it's unnecessary expense and multiplicity of litigation here, my lord. My second ground, my lord, here is with respect to the fact that there will be no prejudice caused. Why? Because there is an order from this honorable court directing status quo in the injunction suit also. So, my lord, it's not like the plaintiff is going to be plaintiff in the suit, my lord, is going to be prejudiced in any way. And lastly, my lord, lordships, I would like to draw the attention of the conduct of the plaintiff. Suit filed in 96, summons served in 2007, my lord.
That is for you. You have avoided service.
Oh, my lord, that's what it says, my lord. My order 9, rule 5 is pending, my lord. But my lord, it's just another factor.
So you had avoided service for such a long time.
My lord, interestingly, this was the prior suit, my lord. It's not that this was the later suit and we failed to act, my lord. They proceeded obviously with the ejectment. Naturally, my lord, it's a larger right concerned there. So, my lord, I'm praying for an order, my lord, that this further proceedings in the injunction should be stayed till there is a decision of the Honorable High Court in the appeal, at least, my lord. But should still kindly consider, my lord.
Praying for not today. Praying for not today. As the Mr. Supratik Sharma is appearing on behalf of the petitioner,
Is appearing?
Mr. Supratik Sharma.
Where is he?
He is unable to due to rainfall. He is unable to cope.
Our revision application is maintainable.
I am not the advocate on record. I am not the judge.
Where is he? He's in another court. He has not come. On the prayer of the learned advocate for the petitioner, hearing of the civil division application stands adjourned for the day. Next. Pass over. Next.
And we have a look at the last line of the order. I will not say anything beyond that.
So bad case, Mr. Chatterjee.
I think for a change, I have a good case.
My lord, item number 23, my lord. I beg to appear for the opposite party port trust, my lord. My lord, we had filed, my lord, a caveat. I don't know, my lord, what the report is, my lord. However, my lord, it was served upon the, my lord, petitioners hearing that a caveat has been lodged, my lord. My lord, may I hand over a copy of the caveat, my lord? I'm just copy copy. My lord, this caveat was lodged on 6th of August, my lord. I believe this
6th of August.
This application has been filed on 11th of August, I believe, my lord.
But the noting is that there is no caveat.
Fine.
The noting is, but Mr. Chatterjee, if you have did that. Order 41, Rule 27 rejected without.
My lord, let them serve a copy, my lord. I am led by Mr. Dotto. Once they.
Oh, no. Right. What are you saying? You have filed a caveat with respect to the 662D of the estate officer. This is from the appellate court.
Yes.
Then?
No, the caveat contained the order of the appellate court as well, my lord, 31st July.
Mr. Chatterjee, give him a
Just
copy.
give me a second. This needs to be settled. We will.
Please give him a copy even without the.
Okay.
Please give him a copy. Where is Mr. Dotto? Mr. Dotto has come. Which Mr. Dotto?
Proceeding is
পিপি অ্যাপিলে অর্ডার পাস করেছে এই তো পিপি অ্যাপিল
Well, they are. We were apprehending they will challenge my lord, some other order, my lord. That's why. My lord,
Hey, this is a 24th June order.
না এটা অন্য অর্ডার
আজব কথা তো।
my lord, emanating out of the same proceedings, my lord, I believe. My lord.
Acha, accept that you made a mistake. Don't need to get into it. Accept it. It's fine. I'll give you a copy. But, I have.
Who is appearing?
Mr. Dotto, my lord.
Mr. Dotto.
Mr. Kishore Dotto, my lord.
Where is he?
My lord, he had appeared before your lordship on the last occasion.
He has come to court.
No, he is not there, my lord, in town, my lord, till.
He had said in that
he had
matter he was
informed.
not.
He'll be there Wednesday onwards, my lord. He has requested if it could.
The problem is, I'll do something. I'll say something. I would not have said anything. Problem is, port trust is not bona fide anymore. What they've now done is, my lord, they have filed an application for preponing the next day, and they've preponed the date. So let him give an undertaking that he will not proceed in the trial court. I have no problems. I'll serve a copy and come back. Now, see what's happening. Even the other matter, my lord, your lordship said the matter. In the back, by giving a back date, they passed an order, my lord, saying that the proceedings are over.
No, my lord. That is not, my lord. We had mentioned before your lordship, my lord, that they had
it's
knowledge
not
of the
fair.
final order, my lord.
It's not fair.
They had knowledge of the final order, my lord.
We had no.
My lord, I have documents, my lord. We can file
They
affidavits.
are not acting fairly. That is what my problem is. Kindly stays it. I'll serve a copy on my learned friend.
Because the caveat is not against this order.
My lord,
You have filed an application for preponing.
whether, my lord,
then
if
this
that
shows
application, my lord, if I'm not aware, my lord, when that application is supposed to be heard, my lord, if that application is supposed to be heard after Wednesday, my lord, we can, my lord, come before your lordship on Wednesday, my lord.
The application has been allowed.
My lord, my lord, your lordship will kindly record one submission, my lord. Your lordship knows, my lord, there were several matters, my lord, which were PP appeals, which were pending for 30 years, 20 years. Your lordship had passed an order that, keeping in mind SD Bandhi's order, it has to be completed within 1 month. This is the same Bimal Kumar Pawan Kumar, where your lordship in 2025.
Neither here nor there. I'm testing the propriety of the order, which is under challenge in the civil revision application. If you are ready on, can you come? I can
serve.
Yes,
I'll come back.
2 p.m. Please come.
My lord, I'm led by, my lord. I need to take instructions as well, my lord. I'm a statutory authority.
Then
my lord.
it is to be stayed, sir.
Let it be for a, my lord, very, my lord, short period, my lord, so that we can come back, my lord, on day after tomorrow.
Mr. Chatterjee, honored senior advocate appearing for the petitioner may be justified in arguing that an application under Order 41, Rule 27 of the Code of Civil Procedure could not have been taken up and decided in isolation with the hearing of the appeal. First, petitioner is directed to serve a copy of this application upon the learned advocate for the opposite party. Full stop. There shall be an order of stay of all further proceedings in PP appeal number 4 of 2006 pending before the learned additional district judge, first court at Alipur, till the end of the month of September 2026 or until further orders, whichever is earlier. List this matter under the heading motion in the monthly list of
My lord will
September.
kindly not do that, my lord. Let us come back, my lord, day after tomorrow, my lord. Your lordship will kindly takes it up, my lord. Monthly list, my lord. Will my lord suffer, my lord. My lord will kindly, my lord, any day, my lord. Apart from monthly list, my lord, your lordship will.
The next matter.
Copy has been served.
Yes.
My lord, in item number 24, my lord, I beg to appear for
The copy of the civil division application has been served. Direction. Who is appearing?
My lord, in item number 24, my lord, I beg to appear for the petitioner, my lord. Kindly permit me to address your lordship virtually, my lord.
Yes, yes.
My lord, the impugned order is, my lord, 4 pages after page number 53. By this order, my lord, I prayed for an adjournment on my medical ground. My evidence was closed. I made a time prayers putting my medical documents, and my time petition states that my time petition is at page number, my lord, page number 52. And by the impugned order, which is order number 59 dated 21.
What happened on 12th of August? What happened on 12th of August?
My lord, prior to that, my lord, your lordship will kindly take up, my lord, one thing, my lord. Page number 49, your lordship will kindly take up. Page number 49. I'll indicate, my lord. Page number 49 is your lordship's order, my lord. Prior to that, my lord, we had filed an application seeking amendment of the written statement. That application was rejected. From that rejection, we came up.
What happened on 12th of August 2026? That date was fixed for arguments. What happened on that date? What happened on 12th of August?
My lord.
What happened on 12th of August?
My lord, I'm saying, my lord, an adjournment has been prayed on 12th of August, my lord.
Now it has been fixed when?
My lord, that information, my lord, we don't have, my lord, because this is from the, this is not uploaded. On the next date fixed, my lord, we will appear and give our evidence, my lord.
By the
Here the petitioner is the society, registered society. The opposite party number 1 loan from the society. He was irregular in making of the payment of his installment. My lord, that is why demand notice was issued. But thereafter, my lord, after getting demand notice, he has approached before the consumer court, my lord, where he's making some disputes. Disputes, my lord. But in the cooperative law, your lordship knows, my lord, there is a clear bar in the consumer dispute forum, my lord. And my lord, a non-material petition was filed, and that has been rejected, saying that the
Appeal is there.
my lord,
Appeal is there.
no, my lord, there is no appeal.
Against the district forum's order, there is no appeal in the.
My lord, state forum, my lord.
Yes.
My lord, kindly, my lord, there's a order has been passed, my lord. There is a basic error is passed by the, my
Maybe.
lord. My lord,
Please prefer an appeal.
When I appealing for the appellant petitioner before lordship, before lordship travels to anything, lordship will kindly comes to page 33 of my application.
What is the impugned order?
Impugned order is there, the appeal is pending. In the meantime, there was an eviction.
Appeal is pending. What appeal is pending?
Lordship will kindly take. I'll come.
What is the impugned order? Please tell me thereafter.
Impugned order is that I want a disposal of my appeal, but at the same time, I also want to.
Of what appeal?
It's a appeal against a demolition order. Demolition order. But what I am trying to seek is, Lordship will kindly comes to page 33 once. I'll go there.
Yes.
Lordship will kindly sees the appeal arises, paragraph 2. The appeal arises
33.
Yes, yes. But this is an appeal. The order passed in the division bench, man. Yes.
Yes.
Yes. The appeal arises out of an order dated 16 June 2026 passed in WP and so and so. We are in agreement with His Lordship on the issue that the appellants did not have any remedy before the writ court. His Lordship recorded that as the appellants were interested to prefer a statutory appeal, no further order be passed. Now, this thing has been passed. Now, Lordship will kindly takes to page 34, paragraph 6.
Yes.
We are not inclined to express anything on the issues raised by Mr. Ghosh in view of the fact that such issues can also be adjudicated by the tribunal upon hearing the parties. The right of the appellants to maintain an appeal as tenants and not as persons responsible for the unauthorized constructions will be decided by the tribunal with this point is raised by the corporation. Under such circumstances, in order to give a breather to the appellants who wish to move the tribunal, we direct the corporation to stay its hands for a period of 1 month. If within the aforesaid period no protective order is passed in favor of the appellants, the corporation may proceed accordance with law. Now, immediately after this order, I preferred an appeal that is a certified copy I have annexed.
Before
that, appeal before the building tribunal. Now, the building tribunal, the learned judge is not sitting, is lying vacant. Now, in the meantime, the corporation is coming and trying to break through the entire demolition proceeding. They want to proceed with the entire proceeding. I am only seeking Lordship will kindly pass an order for expeditious disposal of the appeal. But in the meantime, still the hearing of the stay application is done. I should be protected because already this division bench has specifically stated the issue whether I am my appeal is required to be heard or I have a right to appeal, that has to be decided.
Wherever stated that the bench is not available.
Yes, yes. Lordship will kindly come, paragraph 16 and 17. Paragraph 16, Lordship will kindly takes the petitioner states that in as much as the corporation authorities are seeking to take steps for demolition of the building in spite of the appeal being filed at the instance of the petitioners, and the petitioners through their advocates sought to move a put-up application. Now, paragraph 17, the petitioner stated that it has come to the knowledge of the petitioners that learned tribunal is not in session on and from 3rd August 2026, and it had also come to the notice of the petitioners that learned tribunal shall not take up any matters for some time. And my lordship will kindly see the certified copy. The date has been fixed on 21st September 2026. Well, I am, my lordship will kindly pass expeditious disposal. I don't have any problem. But till that time, I may be protected till my hearing in respect to the issue, whether this appeal is maintainable or not, that may be decided. Only I am seeking this one and nothing else. As there is a division bench order, they have not challenged against anything. But that order, pursuant to that order, I have preferred that appeal.
Are you the person responsible for the unauthorized construction?
That has to be decided. I've shown that paragraph. That is the division bench.
For the purpose of passing an interim order, you have to satisfy your primary
Yes.
case.
One thing, if your lordship kindly is subject to correction by your lordship, 400 subsection 3.
You serve a copy. Mr. Chattopadhyay, learned advocate appearing for the have they come?
Yes,
to
yes.
demolish?
Yeah, I have
When?
specifically stated. I have
When?
paragraph 16, paragraph 16 I have stated.
Yes, where is the notice?
The notice already, lordship will kindly see the division bench order. If I cannot get an order from the tribunal, then they will proceed.
Go before the division bench.
21st August, lordship will.
Because the time
There no coercive action till 21st. I am not seeking a day extra.
Yes, next.
I appear for the petitioner, my lord, is an expeditious disposal of miscellaneous appeal, my lord.
Arising out of?
Order of injunction, my lord. The suit was filed by the plaintiff. Order refused, challenging their preferred appeal. Injunction against me only, my lord. I have filed objection as well as a 39 Rule 4 application also.
You are the defendant.
I am defendant number 1. The injunction is against me only from enjoying the common area of the suit property, my lord. I cannot enjoy the electric room, pump house, anything.
The service is not complete.
Kindly cease, my lord, the order of injunction, my lord.
No. In the miscellaneous appeal, the service of summons is not complete.
But the injunction is only against respondent number 1, my lord. Kindly cease the injunction order, my lord. Order number 3, my lord. Last portion. Order.
Page.
Impugned the certified copy orders, my lord. Order dated 21/4/2026, my lord. Last portion. Thus, I am inclined to grant ad interim order of injunction ex parte restraining respondent number 1. Not any other parties, my lord.
This application. You have?
For the opposite party, Manoj.
Yes,
But
yes.
may I just make one
What is
prayer?
problem? Two Banerjees on two sides.
No, it's a bigger problem, Milord. This is a matter
Bigger problem.
when,
What is the bigger problem?
well, one chamber junior of mine is making personal allegations against another chamber junior of mine, which is why I want to be there physically to do it. Lordship will keep it tomorrow. The DRAT matter was there today.
Did I just make it clear?
Mr.
Milord, there
Banerjee,
is
what
no
is,
allegation against any learned advocate.
No,
Milord,
no,
I
there
will
is.
not
Milord,
argue.
this
Milord, I
I
will not
request
ask any
Mr.
point which will have Milord
No, no,
any
but
kind
I
of
don't
bearing
want
on
Mr.
any learned
Siddhartha Banerjee
advocate.
to get into this, but this is about my own chamber. Lordship will keep it tomorrow. I can see Mr. Dhutimay Paul sitting there and smiling. This is my chamber. Dhutimay Paul versus Shashwat Naik. Lordship will allow me to come there physically
Mr.
tomorrow. The
Banerjee, if
matter
it is the fact,
Nothing to
can
do
you
with the learned advocates,
sort
Milord.
it out?
I'll personally, Milord, speak with
I'm
Mr.
adjourning this. I'm only making it not today.
Nothing to do with the learned lawyers, Milord. It's all about the litigation. Milord, I'll come back. Mr. Banerjee is in difficulty today. I can understand. I'll
Let me
come
come
back.
there tomorrow, Milord.
If
I'll also have a
Mr.
word.
Banerjee, that's on merits is a different thing. I will.
Absolutely.
But if it is touches
Nothing,
upon
Milord.
any of the
Not at
juniors, please, both of you are there. Please try to sort
Yes,
it out.
absolutely.
Don't,
If Milord kindly, Milord stops the live streaming otherwise. Milord,
Then I will go. Mr.
না, না, না,
Banerjee.
এই
না, না,
live
এটা
streaming
তুমি থাকবে লাইভ স্ট্রিমিং টা জাস্ট তুমি থাকবে তোমাকে সরিয়ে মামলা হবে হাইকোর্টে I would not have accepted the brief Milord had there been any semblance of allegation against any
Milord,
learned.
I actually.
In the X second, I'm sorry, in the Milord, there was a. May I should have. হয়ে গেছে দাদা?
Against that defendant.
substitution application filed beyond 90 days.
90 days.
Then,
Yes,
without any
Milord,
prayer for
I have
setting
filed-
aside abatement.
No, Milord, I have filed an application under Section 5, Milord.
Without setting aside abatement, Section 5 is a different thing.
Milord, your Lordship has also held, Milord, there is Supreme Court judgment also, Milord. There is substitution.
Unless there is setting aside abatement.
Along with setting aside abatement.
Unless there is setting aside abatement, how can Section 5 come in?
Milord, your Lordship has also held. Your Lordship has also held. Following Mithai Lal's case, Milord, your Lordship has also held.
Without it's defective application, Mr. Mondal. Section 5 comes after setting aside abatement. So without setting aside abatement, how can Section 5 come in.
Not all. Lord, it's not a suit, Lord, it's a probate proceeding. Lord,
Maybe.
it is between me and the court. I have to dispel the suspicious circumstances which were prevailing.
Where is the application for substitution?
Lord, page 24.
No, I remember you argued that it cannot be done.
I cannot
That
be
is
act
coming in
twice.
my mind that so it cannot be unless there's a prayer for setting aside abatement, substitution after 90 days cannot be allowed.
Lord, I cannot be axed twice.
Because otherwise these provisions under the statute will become ocious. That was the argument I think you perhaps argued in that matter. So that is still in my mind. Yes.
Page 24, Lord, it's the application for substitution.
No explanation also, Mr. Mambo.
Page 26, Lord, I state, Lord, plaintiff came to know.
26.
Page 26 is the section 5 application.
No. In the substitution, section 5 is a section 5 also no reasons.
No, Lord, only one thing, Lord, kindly, Lord, seized. I filed, Lord, the section 5 application, page 26. Lord, in para 2, Lord, I state, Lord, that unfortunately plaintiff came to know on last week the news of the death and also the date of death, and after hearing this.
Your Lordship. My Lord, this is, my Lord, challenging an order passed by, my Lord, West Bengal Regulatory,
West Bengal?
my Lord, Real Estate Regulatory Commission's
RERA,
order.
yes.
Lordship.
Yes.
Lord, my Lord will find the impugned order at page 109, Your Lordship.
109.
My Lord. My Lord, the opposite party had filed a complaint. My Lord, various orders were passed by the authority for exchange of pleadings. Finally, my Lord,
For
by an
exchange of?
pleadings, my Lord.
Yes.
Finally, by an order dated 13th April 2026, my Lord, the complaint petition was granted in favor of the complainant. And my Lord, I am the developer. I was directed to make some payment to her. My Lord, in the meantime, my Lord, after passing of that order, we have filed statutory appeal within the statutory limitation. My Lord, when the matter again was taken up on 10th of July 2026 by the authority, my Lord, we have informed the authority that we have filed the appeal, but the appellate tribunal, my Lord, could not be constituted due to lack of quorum. And that orders were, my Lord, communicated to us by the appellate authority by email communications. My Lord, I have annexed those documents. Lord, kindly, my Lord, first take page 101. That is the main
What
order.
are you challenging? Which order you are challenging?
Lord, I am, Lord, technically challenging order dated 10th of July 2026. If my Lord kindly comes to page 109 once.
Yes.
Kindly sees, my Lord. Complainant such and such is present in the hearing. The respondent Bagaria Realty LLP is presented by the learned such and such advocate appearing online with such and such advocate, authorized representative, and is present in today's hearing physically on behalf of the respondent company. Then below the next paragraph, complainant has filed an execution application, but continual hearing is not disposed yet. Then next, respondent submitted affidavit dated 10th of June 2026, declaring abidance to section 6 and section 11 of the Real Estate Act. Heard both the parties in details. The learned counsel
You have a copy of the act.
Lordship. My lord, section 63, my lord. Lord, this was done in gross violation of principle of natural justice. If my lord kindly sees section.
Where is the provision for appeal to the appellate tribunal?
My lord.
Which section?
Lordship. Well, 53, my lord, envisages the powers of the tribunal, my lord.
Have you deposited this 30%?
My lord, may I, my lord, first take through, my lord?
No, have you deposited this pre-deposit amount?
There was no question of me depositing, my lord.
Why?
Because, your lordship, the tribunal could not be constituted.
For depositing, constitution is not necessary. There is no appeal in the eye of law unless you deposit.
If my lord grants me liberty, we are willing to deposit the 30%.
Shall not be entertained without the promoter first having deposited. So it's a no appeal in the eye of law unless you deposit.
My lord, we were under the impression, your lordship, that once the appeal is taken up for admission hearing at least, my lord, and my lord, the order is passed by the appellate authority, we shall deposit.
It will not be taken up for hearing.
But my lord, the order that is impugned herein, my lord, that does not go by that section. That says that since there is no bar, even if we have filed an appeal, there is no bar to proceed with it. My lord kindly sees he has imposed 2 lakhs of penalty. My lord, section 38, if my lord sees, my lord, the authority has to abide by the principle of natural justice, which he has not done, your lordship. Kindly, my lord, sees.
There is no appeal in the eye of law. If there is no appeal in the eye of law, there is no bar in proceeding with the execution.
My lord, execution also, my lord, he is not saying. He has penalized us.
Yes, that's in execution. That's in execution.
If my lord again kindly sees, my lord, the order.
Yes.
My lord, the complainant has filed the execution proceeding.
Yes.
The learned authority says that execution is not maintainable since this proceeding has not been completed yet.
Yes,
so this is not in execution, my lord.
There is
Kindly seize the order once, your lordship.
yes, complainant has filed an execution application. 10th of July 2026 order.
Yes.
Yes, on execution.
But continual hearing is not disposed yet.
Yes. So execution application.
He has not entertained, your lordship. That day he has not entertained the execution petition. He has, my lord, I am being led by Mr. Gupta.
Shortest possible point this revision is on. I am being condemned unheard because of the non-constitution of the appellate forum.
There is no appeal in the eye of law, Mr. Gupta. Please see the proviso. It shall not be entertained unless you deposit.
I understand.
Please deposit that pre-deposit. Otherwise, no order of no interim order.
We had preferred it within the.
Mr. Gupta, please see the proviso. Section 43, 5 proviso.
We'll deposit within 2 days and come back to your lordship. Give us 2 days.
Otherwise, there is no appeal in the eye of law.
I am told the procedure is that first day
it will not be entertained, Mr. Gupta. Please see the language.
I've seen that. The language
entertainment is
that is why I did not even open my mouth when it fell. I'm only saying that is the procedure followed there. So
cannot be the procedure. This is the same language in
the next date is the next date over there is 20th.
Could we come back on the 19th, my lord?
On the prayer of Mr. Gupta. এই মান্থলিস তো দুটো থেকে লেখা আছে। ও ও ওইগুলো উপরের গুলো, ইয়েস।
Your Lordship, I appear for the opposite party. Your Lordship, the arguing counsel, her mother passed away 2 days back. So, Your Lordship, we seek an adjournment for 10 days, Your Lordship.
You are for the opposite party?
Yes, Your Lordship.
None appears for the petition.
Your Lordship, for 10 days, Your Lordship. 10 days, Your Lordship.
I could not follow. Please use the microphone.
For 10 days, Your Lordship.
For 10 days, why?
Her mother has passed away, Your Lordship.
For 10 days, I cannot adjourn because I do not know the urgency of the petitioner. Please come tomorrow, then I will consider.
Lord, item number 813, I am for the opposite party.
None appears for the petitioner. The opposite
Lordship.
party.
Your Lordship, I am for the petitioner.
In 813?
Yes, Your Lordship.
Yes,
In
please start.
813.
Yes.
My lord, the opposite party plaintiff had filed an application under Order 18, Rule 17, which has been allowed by the learned child court below. Against that order, I am in this revisional application, Your Lordship. My lord, the Order 18, Rule 17 to be allowed at the instance of the court, not at the application or instance of the parties. My lord, in support of that, I have placed a judgment, my lord. My junior will hand it over the same. My lord, here what happened, they did not comply with Order 7, Rule 14. Now, to fill up their lacuna or gap, my lord, they file such application with simultaneous various document, your lordship. And it is a merely a eviction suit, your lordship. This is not, there is no a prayer for any declaration of title, anything. This is merely a eviction of trespasser. Those documents which has been mentioned in the order 18 rule 70 application, my lord, those document is not required, my lord.
Where is the plaint?
My lord, plaint at page number 14 onward.
Yes. Yes.
My lord, may I submit? My lord, first of all, my lord, subsequent.
Yes, you are relying upon this 2025 3 ICC 471.
Yes, yes, my lord.
Yes. Which paragraph you are relying upon?
Paragraph number 7 and 8.
7 and 8. Yes. Yes.
My lord, my lord, one more thing. Item number
Yes.
item number 814 of the monthly list is the similar nature of matter, my lord, which has been analogously heard the similar order, my lord.
My lord, the copy of the same has not been served upon me.
In the
I
other
have
matter, you
served.
have not served the copy.
Yes, yes, your lordship, I have served, but
Your other side
due to
is
heavy
saying,
rain,
your other side is saying
my lord,
that
I have
due to
only
yes,
received
what you
it
say.
is already prepared, your lordship. Due to heavy rain, I could not.
Yes, yes.
My lord, first of all, the PW1 has been stand closed. Subsequent to my lord, they have filed the application, my lord. The trial court did not grant any stay, my lord. Subsequently, my lord, PW1 was hard, stand closed, my lord. Upon examination and cross-examination, these are the orders.
After
My lord,
recall.
prior to that, I have filed. My lord, prior to that, I have filed the application. Prior to
My lord, kindly come to the last order, my lord. Order number 22, dated 21st of July, 2026.
my lord, prior to recall of PWD1, I have filed the instant revisional application.
And my lord, they have been the PW1 has been cross-examined by the defendant as well, my lord. Defendant petitioner.
My lord, in their order 18, rule 17 application, the schedule of the said application, there are 6 documents, your lordship. They should amend their plaint. And this is a mere eviction of trespasser should where the money received and the deed of sale
Because my lord, in
agreement. There
cross-examination,
is
they have put that
no
question
prayer
before
of
the
any
learned trial
declaration,
court
your
below.
lordship.
Before the
My lord,
learned
there
trial
has
court
no
below, my lord.
prayer of declaration. It's a merely eviction suit. If he is a trespasser, the suit will be goes accordingly. Now the 5 document come in recall application. It
No,
will change the entire nature and character of the suit, your
no, my
lordship.
lord, certainly not, my lord.
This
It will change
application
the
under
nature and
article
character of this. The 5,
certainly
6
not, my lord.
documents, your lordship,
This
of title.
Challenge
application
it.
under article.
My lord, another item number may be taken up analogous to your lordship.
This application
814.
Yes. Page 31.
My lord, page 31.
The PW1. For all the reasons as aforesaid, yes, call the next matter. Yes.
Petitioner is the defendant in this matter. File an application for handwriting expert of the money received.
Application for?
Handwriting expert. For the handwriting expert. Already 2018 year handwriting expert was application was allowed, which was filed by the plaintiff. The allegation of the defendant, the contention of the defendant lordship, the money receipt which was executed by the allegedly executed.
Please give me a minute. Yes.
2018 lordship, page 51. The handwriting expert application was allowed, which was filed by the plaintiff.
Yes.
The money receipt, which was executed in 2005, and the Vokalatnama, which was filed in 2008, and original plaint, which was filed in 2000, was not sent to the department CFSL for the expert opinion.
Yes, it was sent. The court holds that it was sent. What's the basis of your statement that it was not sent?
This lordship, the handwriting expert given an opinion, which is page lordship.
Yes.
Page 60.
Page?
Page 65.
65, yes. Yes, so these were received by him.
2016, the phrase Vokalatnama was filed, and several times they have amended
This application under Yes.
The 13,
Caveat is there.
they have appeared.
Lordship, I appear on behalf of the OP number 1.
Yes.
Whatever your lordship, I am ready with the matter of the trial.
All right, not today.
Because it will be taken up tomorrow. Because if it goes down in the list, then I will suffer.
No, it's up in the list.
Why I am saying
Above the matter, starting the matters.
why I am apprehensive. My father allegedly was a guarantor for a person who had taken loan from the bank. Later it was found that my father was nowhere involved. What the bank did was they issued a 13-4 notice. Once they issued a 13-4 notice, I had to get out of that, paid the bank the money which the borrower owed. Then I found out my father never took any money. I went to the police. The police said that deeds over which the loan was granted are forged, and they destroyed those documents. I have now filed a suit to bring my money back. There are interrogatory applications which were disposed of by saying that the bank will secure it. Not the bank, now that it's the asset reconstruction company. I am saying under order 13 rule A, they don't have any defense against what my claim is. And I'm saying kindly give me back my money by way of a preliminary in a bank. That has been rejected, not against which I'm before you. I'll show before your lordship. They are admitting that my father was not the guarantor. It's admitted fact.
All right, come tomorrow.
This is why we are wanted it to be ordered. They get money from me by issues.
Really at the top, Mr. Chatterjee, it's above the matters.
His matters are
Yes. Please use the microphone, Mr.
Yes.
Yes.
This is in the order impugned passed by the London Civil Judge Senior Division Katwa on 17 June 2026, the last page. And if your lordship kindly go through, Lord, what has happened in this case, Lord? The petitioner before your lordship was the defendant in the lower court, London lower court, and where Lord this suit was filed by the plaintiff claiming to be the owner of the property and for eviction, but under the specific relief act, section 6 of the specific relief act. Blood a notice prior to that filing of the suit, a notice was given. What was actually his
Section 6 of the specific relief act or the West Bengal Premises Tenancy Act?
No, not premises tenancy. Not premises tenancy. Lordship,
Section 6 of the specific relief act.
Kindly allow me, Lord, only what was happened. The history of the case is mother was the owner of the property. The agreement was entered into by the mother and the defendant.
What is the impugned order? By the impugned order, what
the
was
order
done?
41 Rule 2 application was made before the learned appellate court.
Suit was decreed.
Suit was decreed in favor of the plaintiff.
Yes.
Against that appeal preferred.
You have preferred an appeal.
Appeal was admitted.
Section 6, there is no appeal. Section 6 of the specific relief act, against that appeal does not lie.
Blood, we have taken the point, Lord, section 34 of the specific relief act. The suit is not maintainable.
Mr. Banerjee, if it is a suit under section 6, appeal is not maintainable.
Where is
the plaint? Where is the plaint?
Plaint, Lord, first annexure, Lord, at page, Lord, 13.
No. This is not a suit for section 6 of the specific relief act. It is a suit under section 6 of the West Bengal Premises Tenancy Act.
Premises Tenancy Act, Lord, but Lord, the specific relief
not specific relief act.
But kindly, Lord, kindly consider the issue framed by the learned court below.
Yes.
At page 26.
Yes.
Whether the suit is maintainable in its present form, whether the plaintiffs have any cause of action to file instant suit, whether the suit is barred by the law of limitation provisions of section 34 of the specific relief act, whether suit is bad for misjoinder and non-joinder of necessary party, whether notice to quit dated 6 September 20 is illegal, valid, properly served, binding upon the defendant, given a habitual defaulter in making payment of rent, whether plaintiffs have any other reasonable and suitable accommodation save and except the suit property. But yes, file the suit for the need of accommodation. But the agreement entered between the mother and the defendants. Mother expired. But we have been paying the rent. It was enhanced after 5 years, 20%. And we are paying the rent. The plaintiff, the son of the mother, accepted the rent. But my contention is this, since appeal is admitted, stay was granted, and it is continuing. I have annexed the order. Continuing. But my case is not the notice which was taken into consideration by the land court below, the lawyer's notice, that they kindly vacate the possession and no rent has been received. But fact remains, we have replied to that.
That will be decided in the...
We have replied to that. We have replied, yes, after the, before the notice, you have accepted the rent. But that documents I want to place before the appeal court.
Document was not produced before the trial court.
Notice was exhibited.
But the reply was not.
The reply was not.
And then you have to take out an application under Order 41, Rule 27. You have to take out an application.
But 41 to kindly see the order, impugned order. how my case, my application has been rejected. Well, kindly, may I read from your lordship?
No, I'm going through that. Oh, you want to incorporate certain grounds.
Ground.
So you wanted to amend the memorandum of appeal
My lord.
by incorporating certain grounds.
My lord, two grounds. My lord, only my lord, that was rejected.
Uh,
It is very clear, but subject to correction by your lordship.
where is the written statement?
Written statement in the suit.
Yes.
Yes, Lord, your lordship will find from page 16. Page page 18. Paragraph 7 is very clear, page 19.
Oh, Mr. Banerjee. So you wanted to amend the memorandum that you are not a defaulter.
My lord.
That issue is in your favor, decided in your favor. Please see page 30, issue number 6. They did not agitate this point. So they have admitted that you are not a defaulter. That is why issue is answered accordingly. So you are saved by that. Nothing.
Blood, only.
It's not necessary because issue of default they have not pressed. Issue of default they have not pressed. So you are not affected. Ashun, this application under Article 227 of the
Constitution. Kindly, give a direction to the appellate court to hear out the appeal within.
Yes, that direction I will pass.
But without being influenced by any observation passed by your lordship.
Yes. I'm directing the appeal to be disposed of because you wanted to amend to incorporate that reply to show that you are not a defaulter. Default count they have not pressed.
My lord, kindly.
This application under Article 227 of the Constitution of India is at the instance of the defendant / appellant in title appeal number 16 of 2024 and is directed against an order dated 17th of June 2026 passed by the Learned Civil Judge Senior Division, Katwa District, Purba Bardhaman. So, by the order impugned, the application under Order 41, Rule 2 of the Code of Civil Procedure stood rejected. Mr. Banerjee, Learned Advocate, appearing for the petitioner, submits that in reply to the notice to quit, the petitioner has issued a reply notice, as
Right, sir.
Pass over. Next. Pass over. Pass over. Pass over.
My lord, item number 29, I am appearing for the petitioner. My lord, am I audible?
32 you are appearing. 32 din.
My lord, item number 29, I am appearing for the petitioner. Am I audible?
Defendant is the petitioner before your lordships. I have come against order number 170 dated 21st May 2026, my lord, allowing an application under section order 617, my lord, amendment of plaint, my lord. And against that order, I have come, my lord. My lord, what happened, my lord? The present plaintiff filed a suit for partition and permanent injunction. My lord,
কি ফাইল দিয়েছেন?
My lord, item number
File is 32
29. Lordship, am I audible?
32
Item number 29, I am appearing for the petitioner.
32.
Sukumar Chatterjee. Sukumar Chatterjee.
Lordship, am I audible?
32. Sukumar Chatterjee.
Sukumar Chatterjee, 32.
Sukumar Chatterjee. Yes. Yes.
Am I audible to the honorable court?
I have filed an application for amendment of plaint, my lord.
Yes.
What happened, my lord? At the time of final hearing, my lord, the PW1 evidence was closed, my lord. Next date was fixed for evidence of PW2. They filed an application for present amendment application for incorporating another property, my lord. That property. But that is not the property of the plaintiff, my lord. Well, I have annexed, my lord. Plaint, my lord.
It prima facie appears to this court that the application under Order 6, Rule 17 of the Code of Civil Procedure was allowed by a totally non-speaking order. First, a petition is directed to serve a copy of this application by registered speed post with acknowledgement due upon the opposite party.
Huh?
29.
32 for
32
29.
করলেন।
Number 30, I was not in the lobby, my lord. I waited, but your lordship's officer did not permit us.
Lordship,
Yes.
item 29, I was present. Lordship possibly could not hear me. I was present, Lordship.
Yes, yes.
Yes, my lord. With my lord's leave, item 29 is an expeditious disposal matter, my lord. I am praying for expeditious disposal of the matrimonial suit pending before the learned third fast track court, Barashat. May I take my lord through the relevant dates?
What is the stage of the suit?
Lordship, issues also have not been framed yet.
Yes, issues have been framed.
Lordship, 11th July 2024 was fixed for framing of issues. Thereafter, Lordship, chief, affidavit in chief is there, Lordship, but matter is not proceeding to witness action. Kindly seize, my lord, I have filed my affidavit of evidence way back in September 19, 2024.
Any application for alimony penalty lite?
No applications are pending, my lord. In fact, the conduct of the respondent wife has occasioned the learned trial court to show cause the respondent on
This
several
application under
occasions.
Article 220.
Item number 30, my lord, if your lordship takes up. Item number 30, I was there in the lobby, my lord. I could not join because your
Why,
lord,
Mr. Mukherjee, could not join?
I was waited in the lobby, my lord. Your lordship's officer, my lord, did not permit me, my lord, to join. That's why item 30, it's an urgent matter, my lord. It's regarding the, my lord, passport of the minor child.
In Howrah lobby.
Howrah lobby.
Howrah lobby.
Mr. Basu is also there, my lord, with me.
He has come physically. Mr. Mukherjee, he has come physically.
Because he lives, my lord, in a better place, not like my place.
You change your residence, Mr. Mukherjee. Come closer to Mr. Basu.
I can't, my lord. I can't afford.
Yes, yes.
It takes up, my lord, this is an application under section 12. My lord, if your lordship takes up directly, my lord, to my lord, page number 67 of your lordship brief.
Yes.
But I shall place only, my lord, paragraph number 8, 9, and 10. My lord, at page 69 and 70 of your lordship's brief. Kindly, my lord, goes through, my lord, paragraph 8, 9, and 10. Has your lordship got it? Not 8, 9, and 10.
Yes.
Now, my lord, kindly see one page only. Thereafter, I will take your lordship to the order impugned. Page 64. This is the communication, my lord, of the United States Department of State Western Passport Center to my client.
Yes.
Now looks at my prayer, my lord, in section 12 application, which I placed before your lordship. The prayer is at page 74 of your lordship's brief. Now this has been dealt with, my lord, by the order impugned, stating that this cannot come under the purview of section 12. That's why, my lord, my application was turned down by the order impugned, my lord, order number 7 dated 7th of July 2026. Admittedly, my lord, the child is under the temporary custody of the mother.
Yes.
Act 8 proceeding is pending. 2021, my lord, he is by birth, my lord, the citizen of USA. He was in New Jersey. We came back due to, my lord, certain allegation between the parties. I am not on that. But regarding the renewal, because the initial, my lord, 2021, my lord, issuance is for 5 years. That has got lapsed. For renewal, the embassy is asking this. If you having the custody, get it clarified by an order of the court that yes, the temporary custody is with you and you are permitted at least to proceed with the documentation for renewal of passport. That pilot for that, I asked for this order under section 12. The learned judge on a technical sense said it cannot come under the if your lordship takes up the language of even section 12, it's for the interest and benefits of the child and his property. What I intended to do is for the benefit of the child.
You come within which limb of section 12, Mr. Mukherjee?
I say, Lord, if your lordship takes it up in a sense that subsection 1 of section 12 makes it
Yes.
that it may make such order for the temporary custody and protection of the person or property.
Yes.
So it's not only the protection, it's a protective order for the rights of the child only. He's a US citizen, his passport got lapsed in 2025. I want my minor son's passport to be renewed. Nothing else. It's for the benefit of the child.
The passport is with whom?
The previous passport and all, Milord, I have not in the application itself, I have stated it is lying, Milord, with the father. Kindly take the paragraph 8 once. Paragraph 8, I have stated.
Now, you want the father to produce, to give you that passport.
The passport is
No.
lying with the mother only. We have applied for renewal. The passport is lying with the mother only.
Oh, passport is lying with the
only
mother.
permission to apply for renewal. That's it.
And for that, Milord, I have shown before your lordship that page the embassy is asking that clarified order. That is at page 64 of my lord's brief. Clarified order from the court that being a single parent, I may be allowed to proceed with this plot renewal application. That's the communication dated 6th of April 2026. And after
Mr. Mukherjee.
This side has lost a caveat. Already
we have served, but your lordship, Milord, keeps it in a supplementary list, Milord. I am not asking for anything else. Keeps it in a supplementary list so that, Milord.
That will be adverse, Mr. Mukherjee.
No, not
today.
adverse, Milord.
Yes, yes.
The child
Pasu is here. I will not take any risk.
Lordship would
Yes.
keep it on Friday any day.
But
Your lordship, because the child is suffering, your lordship. That's all.
Let me see. Yes,
Lordship
next.
Fix it any day. We'll come up with the notice, your lordship would.
Let me see. Yes, next.
Lord, may I give another notice to the caveat?
Please give another notice. Yes.
Lordship would kindly fix it up because he has no other document to travel.
I will consider. Yes. Next. Pass over next.
Experience disposal. I know. The impression.
Rejected.
Janbari.
Rejected.
A peculiar thing, well. Suit for recovery of possession decreed.
That is the volume of the expeditious.
Don't touch it. I'm giving the dates. Can you hear it? I'm giving the date. 28 February 2017, suit decreed expiry for recovery of possession.
What is the suit for?
For recovery of possession. Can you see the fate of Rani Rasmani's family? Then, my lord, this was recalled expiry on 2018. Again decreed in 2022. Title appeal dismissed. Second appeal dismissed.
Execution case.
Then peculiar thing. This is school. Now the primary, the government authority, which is, my lord, primary, Kolkata Primary School Council, now file
Kolkata Primary School Council.
Now file an order 21 rule 9700. That is continuing.
But order 21 rule 97 to 100 is pending. That is to be
that has to be disposed of as early as possible. Nothing else.
it's ready for hearing. Written objection filed.
Written objection is filed by my client. Yes.
What is the next date for?
Today was the date due to for hearing.
23rd July for hearing.
Hearing of this order 20/97.
No, Mr. Basu, please kindly come to the order dated 13th of May. It's for passing further orders. So hearing might be completed in the meantime.
No. Today was the date. Today
Please
was
see the order dated
I've
13th of May 2026.
seen that, but my client is present in court, my lord.
But
There was a date.
Presiding officer is not there, Mr. Basu.
Yes, come. Yes. My instruction is he has joined.
That I do not.
My lord cannot bypass me anyway. Today was the date due to this weather condition. Today is
decree passed on.
The original decree passed on 28th February 2017.
That's an ex parte decree.
Ex parte decree recalled.
Order 9 Rule 13.
Recall, yes. 8th June 2018.
Then what is the final? Then what is the final? Thereafter the decree was passed when?
Second appeal was dismissed on 30th August 2023.
Which paragraph?
And I'm giving the date.
30th of
synopsis keep reading. I got it from the
decree.
That will be the date of decree. 30th August.
Decree is 20th of May 2022.
That is, my lord, 20th May 2022 is the dismissal of the decree. This is original decree. Then title
suit was again decreed on 20th of May 2022. So that is after setting aside it's the and then
title appeal dismissed.
Title appeal dismissed on 10th of January 2023.
Second appeal dismissed on 30th August 2023.
You have succeeded everywhere.
Very good case. And the mother's blessing is there.
Ashun.
For the petition. Well, at the time of filing the revision application, there was no caveat. Subsequently, I got a notice of caveat. So if the my lord directs me to, then I can serve. Otherwise,
Please let me see what is this matter. Yes.
so my lord, the petitioner's applications under order 97, 100, 101 was summarily rejected on the ground of maintainability. So my lord, this petition, this property is an commercial unit wherein the petitions
The miscellaneous appeal has been dismissed.
Miscellaneous case was dismissed on the ground of maintainability. Thereafter, miscellaneous appeal was dismissed. Well, the facts, man, kindly come to the only the fact is that this petitioner is carrying on a business of a beauty parlor. Now, my lord, original, the opposite part, the landlord filed a suit for eviction against Muhammad Nasim Khan, who is the original tenant. Now, during the pendency of the suit, the original tenant died. Now, he is legally substituted. Now, this tenant, my lord, executed the power of attorney in favor of the petitioners to conduct the ejectment suit, to defend the ejectment suit due to his personal inability. Now, the learned trial court held that this power of attorney has created a subtenancy. The decree was passed in the ground on the ground of subtenancy, saying that the power of attorney, since created by the original tenant in favor of the petitioner, is a ground of subtenancy. So kindly, my lord, come to the page of my lord, running page, annexure A, running page 11 to 13. So, my lord, I am carrying on business with having all valid documents, and I have got an electric meter with the consent of the landlord. My lord, kindly coming to the running page 13. So, I am carrying on business therein in the suit property, and the landlord resides in the same premises, witnessing that I am in occupation of the suit property. So, my lord, kindly come to the general power of attorney, running page 18. So, my right title interest has not been adjudicated. Even I am not permitted. I was not permitted.
What is your right title and interest?
Yes,
in
I
the
am
property?
carrying on business.
Maybe. What's your right title and interest to remain in possession of the decretal property? Please show me that.
Because with the knowledge of the landlord, I am
Maybe.
carrying business.
Maybe. Adverse possession.
Not that.
Then
Not that.
under what capacity? In what capacity?
Because I am.
Please show me in what capacity. Please show me your application under order 2197.
I am saying. Kindly coming.
What is your right which you have canvassed?
Annexure D, running page 61 onwards, my lord.
Page
61 onwards, my lord.
Yes.
Kindly, paragraph 1. Originally, one Muhammad Nasib Khan was the recorded tenant in respect to one shop room on the ground floor premises such and such. That the respondent number 1 here is the owner of the landlord of the suit premises. That the said recorded tenant died in place solo. That in the year of 1995, the original tenant, namely Muhammad Nasim, approached to the applicant hearing to take over the suit premises, and the rent bill will be changed with the consent of the landlord. That is the respondent number 1. On the basis of the mutual arrangement, the possession of the suit premises was delivered by the original tenant. Since then the applicant is in possession of the suit premises as tenant. It is wrong, which is approved by the respondent. It is hereby mentioned that the applicant had invested such amount for the.
What documents you have to show that you have a right in the property?
So kindly come to my lord.
Yes.
Running page 11 onwards.
Yes.
This is the corporation tax bill. Trade license. Then, my lord, this is
trade license is neither here nor there.
My lord, kindly come
show me that the landlord has recognized your right to stay.
So kindly come to running page 13. The CSC bill got changed in my name with the consent.
Rent trespasser is also entitled to electricity.
My lord, with the consent of the landlord, my lord. With the consent of the landlord.
Anything more?
Nothing.
This application under Article 2.
This disposal, my lord.
Of what?
Partition suit of 2015, my lord.
Partition suit?
Yes, my lord. At the
What is the stage of the suit?
preliminary hearing stage, my lord. At this stage, petitioner filed an application under Order 39, Rule 7. After 11 months, my lord, date has been fixed, my lord. And
Order 39, Rule 7. What is the date fixed?
my lord, it was in
June.
yes, my lord. Next
What
date,
is the next date fixed?
next date, 2nd September 2026. Another of that miss case filed under Order 39, Rule 2A.
No, that is also pending.
That is also pending, my lord. Both the
That has been initiated by you.
yes, my lord.
No, 2nd September is the hearing in the miscellaneous case.
Yes.
And that is also the date fixed for Order 39,
No,
Rule
my lord.
7.
That information I don't have, my
Order
lord.
39, Rule 7, what is the next date fixed?
Last date was on, my lord,
19th of June.
19th of June.
What is the next date fixed?
Initially, my lord, in this matter, my lord, 2015 matter, initially date was, defendant did not appear, date fixed for argument, my lord. Thereafter, they had appeared. And my lord, 2019, although issues have been framed, my lord, mistakenly 2 years had been fixed for framing issues, my lord.
By which order? It has been directed for framing of issues.
Yes, my lord, that is on 21st December 2019, my lord. Issues had already been framed.
No, date was fixed for framing of issues.
My lord,
Issues are framed in a separate sheet.
yes, my lord.
This
Thereafter,
application.
2 years date has been fixed for framing issue. 2 years. 2022, my lord, again date. It was clarified and date was fixed for preliminary hearing.
Thereafter, it has been clarified.
Yes, my lord. On 21st January, 12th January 2022, order number 33.
3rd January.
12th January, my lord.
12th January
2022. It has
for
been
preliminary
clarified.
hearing.
Yes, my lord. For preliminary hearing.
Uh,
my lord. We have challenged an order passed by my lord the Debt Recovery Tribunal, my lord.
Debts Recovery Tribunal.
My lord,
But
your lordship-
appeal is
Your lordship will kindly see, my lord, what has been done. Your lordship will kindly see, my lord. My lord, on 24th, my lord, prior to the impugned order, my lord, the matter was heard considerably on 24th, my lord, prior to the sale, my lord.
where is the impugned order?
My impugned order is of 9th of July 2026, my lord.
9th of July.
Yes, my lord. And my lord, just prior to that, my lord, there is an order of 24th of June, my lord. On the 24th June, my lord, the matter was heard, my lord, judgment was reserved. 29th was sale, my lord, we filed a put-up application.
7th of,
My lord, 9th of July is a order impugned before your lordship.
yes,
And my lord, prior to that, my lord, there is an order of 24th of June 2026, my lord.
24th of June,
Just the page.
23rd of June,
Lord, 24th of June.
24th of June, yes.
Yes, my lord, your lordship, the application for put-up, our application for stay, my lord, because sale was on 29th, we filed a put-up application. We intended to, my lord, get an order prior to the sale. It was heard. Our judgment was reserved, my lord. All points recorded. My lord, however, my lord, thereafter, my lord, the learned tribunal went into vacation, I am told, my lord. And my lord, thereafter, my lord, the order of 9th of July gets passed, my lord. No stay, my lord, no, my lord, at least there is no rejection of my prayer for stay. Your lordship would kindly take, my lord, the order of 24th, my lord. 24th, my lord, our submission has been recorded, submission of the bank council has been recorded. Now, my lord, it is submitted by thereafter, my lord. On the above ground, counsel for the respondent opposes the ad interim order. Order is reserved. The order gets reserved. Now, my lord, there.
No, it was heard, but the learned tribunal felt that an opportunity should be given to the bank to file the objection.
Yes.
My lord, order was reserved.
Stating whether sale has been conducted or not.
No, my lord. Your lordship kindly takes the order of 20.
What happened on 19th of August?
Lord, 19th August.
Oh,
is to
19th of August it is fixed.
Yes.
So I'm directing the to be heard on 19th of August. You have filed your written objection.
My lord, I will be filing by tomorrow.
Then, my lord, what?
Tomorrow. By tomorrow, I will.
By tomorrow you will be filing.
Yes.
Then, my lord, the kindly direct the learned tribunal to, my lord, decide the prayer for ad interim relief on 19th itself, my lord. Lordship,
Finally, if he files the written objection, it will be
because, my lord, the judgment was reserved, my lord. Kindly see,
The
my lord.
judgment
if
was
the,
not
after reserving the judgment, if the tribunal feels that they have to be given an opportunity to file the objection.
But there is no specific rejection of my prayer, my lord. Your lordship will kindly see, my lord.
He has, my lord.
9th of July, my lord, there is no rejection that, my lord, I am not entitled to interim order.
No, my lord. Kindly see the last line. Interim order may be passed after filing objection to by respondent bank and after hearing both parties.
Today we are on 17th. He will be filing objection on 18th. 19th, I am requesting the learned tribunal to decide.
My lord.
Finally, Ashun. The Pass over next. No, not today, business. Yes, what is this matter? What is this matter? Yes, how was revision application is maintainable against this? Decree passed by of divorce on mutual consent. Who is leading you? Where is he? Ask him to come. Pass over. Yes, next.
Item 40, my lord, I appear for the opposite parties and led by Ms. Devjani Shenmukta.
Lord,
I am
not hearing what very much.
My lord,
Where is the petitioner is not here, Mr.
not here. The opposite party, my lord, had served a letter upon me, upon the client, my lord. So we have also served a letter back to them asking for the copy of the application, which has not been served as yet. So it has to be adjourned. They are not here.
देखी फाइल तो दी
Your order perhaps is that is my lord on 16 May 2026.
all right, not today. Yes.
Well, item 41, I appear for the petitioner.
Yes. So Bhattacharya, where are you?
There is no
I have come to Milord Delhi.
Yes, yes.
Well, I have come to Delhi.
Oh.
Milord,
Lordship, I will come to the impugn order. Before
But
that,
Mr. Bhattacharya, your learned friend says there is no caveat. There is no caveat.
Milord, one person, Milord, the bank has lodged a caveat, Milord. Your Lordship is looking at Baba Koilashpati. Your Lordship is looking at Baba Koilashpati.
No.
No.
Oh, I'm sorry, Milord. I'm sorry. I'm just checking it, Milord. My night.
Yes. Yes.
Also, before going to the impugn order, kindly come page 27. This is the first suit. I am the defendant number 1 in the suit. Lordship, kindly come.
What is the impugned order?
Lordship, I will come. Lordship, this is
What is the nature of the impugned order?
Order 7, Rule 11, and Order 23, Rule 1 has been dismissed.
Order 7, Rule 11.
Yes.
And Order 23,
Order
Rule
23, Rule 1 has been dismissed.
Yes.
Lordship,
Order 7, Rule 11. What is the ground?
Now, that's why, Lordship, I kindly come page 30. Lordship, first, the plaintiff filed a suit. Kindly turn page 30. What was the cause of action? That is 20th June 2025.
Page
4. Page 30, paragraph 4. The cause of action arose on 20th June 2025. Now, Lordship, the suit, the plaintiff failed to get the ad interim order of injunction. Subsequently, Lordship, Order 1, Rule 10, amendment application filed. I am not. Now, Lordship, the plaintiff filed another suit on the same, Lordship, the civil property. Kindly come, the match the civil property. It's the same identical parties. Now, this suit has been filed. Kindly come page 50.
Page
50.
Yes.
This suit has been filed through the power of attorney by the same plaintiff, Muhammad Ullah, plaintiff number 2, and Rohima Khatun, who subsequently added in the first, Lordship, the first suit. Now, during the pendency of the first suit, this suit has been another filed and got an ad interim order of injunction. Now, after getting the ad interim order of injunction, they have withdrawn the suit, first suit. Kindly come the order, page 49.
Yes, then what happened?
Without taking any liberty to file afresh, Lordship, they have simply withdrawn the suit. Now, kindly come the second suit. What was the cause of action?
No, your submission is that during the pendency of the first suit,
Yes.
second suit was filed.
Yes.
Now, second suit, they have obtained an order of injunction.
Ad interim injunction.
After that, they had withdrawn the first suit.
Then they withdrawn the first suit
Without any liberty.
preserving their right to file afresh.
Yes. So, according to you, this is the bar under Order 23.
Yes. Now, this is the first term maintainable, that the without any leaving, Lordship, the liberty, they have filed the second suit. Now, Lordship, kindly see the cause of action of the second suit. What was the cause of second suit? Kindly come, page 54. The cause of action of second suit is 23rd December 2025. So, their cause of action to the declaration of title to the property already abandoned on in respect of the first suit, that is June 2025. So after 20th June 2025, the second suit's cause of action is 23rd June 2025. Within the 3 days, there is no such cause of action.
That cannot be decided in Order 7 Rule 11. Whether there is cause of action or not, he has pleaded. You have to go by that plain first. Second is.
Now, I am not beyond the plain. I am in the plain, Lordship, first suit. The cause of action arose within 20th June 2025. First suit, Lordship, pending. Second suit filed. What was the cause of action? 23rd June 2025. So, for filing of the second suit, there was no such cause of action.
Whether there was cause of action or not cause of action, that cannot be decided now in Order 7 Rule 11.
Lordship,
Now,
it appears in the plain. Same line, same property, same schedule, same parties. And Lordship, I filed an application under Order 39 Rule 4 and Order 7 Rule 11. And other defendants filed, Lordship, Order 23 Rule 1. Lordship, my application Order 39 Rule 4 has been allowed.
Yes.
This is I am not challenging. Now, so for the Order 7 Rule 11 concern, Order 23 Rule, that two application has been rejected, which is the impugn order. Kindly come to the impugn order. That is photocopy starts from page 81.
Mr. Mukherjee, one thing according to you, the suit is barred under Order 23 Rule 4. Order 23 Rule 1 Sub Rule 4.
Yes.
That is your submission. Now, whether that bar will apply if during the pendency of the first suit, the second suit has been filed. There is a judgment of the Honorable Supreme Court on that. Have you brought that?
Subsequently, first suit has been withdrawn.
Without obtaining leave, without withdrawing the first suit, second suit has been filed. Then whether this bar will apply. There's a judgment of the Supreme Court on that.
May I clarify the facts? First suit was pending.
I can clarify you the facts.
During the pendency of the first suit, second suit has been filed.
That is what I'm saying. There are two ways. One is, there is one suit. So you withdraw with liberty, you can file a second suit.
Yes, that is no dispute.
That is. Now, first suit is there. With the pendency of the first suit, second suit has been filed without withdrawing, without leave.
Yes.
Then the first suit has been withdrawn. Whether Order 23, Rule 1, Sub Rule 4 will apply. This is a judgment on this of the Supreme Court. Have you brought that? It will not apply, Mr. Mukherjee, subject to correction by you. It applies once the second suit has been filed, this bar cannot apply. Yes, Mr. Mukherjee, do you have that judgment? Mr. Bordon? I think author of that judgment is Justice Sinha, SB Sinha.
So I will check, but Lordship, so far the order 711
Then
concern.
there is nothing. What is the reasoning of the trial judge?
Lordship, kindly come, page 81. And order 711 also, both
Yes.
applications
So
have been-
Order 7, Rule 11, that is the bar. That bar will not apply Order 23, Rule 1, Sub Rule 4.
No, order 711.
That will not apply once the second suit has been filed without obtaining.
Lordship, this ordering portion at page, starts from page 81.
Page
81. The previous page is the Lordship, the order 39 rule 4, which has been allowed.
No, Order 7, Rule 11, where is that?
That's kindly come page 81.
Page 81.
Starts from order, heading order. Page 81 is the photocopy and subsequently the certificate.
You said Order 23, Rule 1 application also has been rejected. Where is that?
Lordship, this application.
No. You have said this only says of Order 7, Rule 11.
Yes, maintainability application has been rejected.
No, you said the Order 23, Rule 1, that application was rejected.
And the petition, kindly come page 82, and the petition regarding non-maintainability of the suit.
Yes, that is Order 7, Rule 11, you have said.
Now, the two application, after Order 7, Rule 11, analysis non-maintainability of the application.
What is the ground of non-maintainability? That's during the pendency of the first suit, second suit has been filed.
That application.
Where is that application?
Application I have filed.
I think there is a judgment. I've forgotten the citation. Yes, Mr. Bordor, you are a ready reckoner.
Page 64.
So Mukherjee, you are carrying that STC online. Can you search? Order 23, Rule 1, Sub Rule 4. That bar, I think, will not apply once the second suit has been filed.
I'm trying to find.
I think it's by Justice Sinha. Or I'm passing it over. Let me see.
Also, kindly tomorrow, tomorrow I will invite.
Tomorrow, there is a
There is no
there is no caveat. Hard. Passover 44. Yes.
My senior joined the wishes.
Yes.
Lordship, I am not the petitioner.
Yes, but there's a
Present
caveat.
the revisional. A caveat already copy has been served, Lordship.
Yes.
There is a affidavit of service. Affidavit of service.
Caveat is not here today. What can be done? Pass over next.
Your Lordship, I appear on behalf of the petitioner in this matter.
Yes, Mr. Dattu, you are here. Adjournment was taken on your behalf.
Your Lordship was wrongly informed, my lord. Last week I was not here.
No, today an accommodation has been paid for on your behalf.
But the person who had informed your Lordship, my lord, felt that I will not be available this week. In fact, it was last week. Mr. Chatterjee told
yes
that your absence has benefited me. That's what he told me.
Because that could have been taken. It was a short point.
Yes.
Because could have been disposed of today.
Well, since your Lordship is saying this, could that matter be preponed?
I do not know what I have done.
May I serve notice and mention tomorrow? Kindly pardon.
Mr. Chatterjee is here.
No, Mr. Chatterjee, I don't think. But I would seek a disposal of the matter before the estate officer within a time.
No, not the estate officer.
Appeal.
That is a PP appeal.
Right.
Order 41, Rule 27 was rejected prior to taking up the appeal for hearing.
Right.
So that could have been disposed of.
Disposed of relegating the matter before the appeal court.
That is why, but where is Mr. Chatterjee? Can you ask you?
Let me find out. Let me find out.
If he can join so that it can be disposed of. Otherwise, yes.
Your Lordship, I'm appearing online in this application.
Yes. What is this matter?
This
Expeditious hearing of what?
of the suit as well as the application of pending. It is heard in full, Your Lordship, the application. Only reply from the other side is left in the trial court.
This application
The last matter was.
You are the plaintiff or the defendant?
I'm the plaintiff, Your Lordship. This
application, this Rule 10. The learned advocate appearing for the petitioner.
Probably 2008, volume 5, SCC, page 58.
Yes, what does it say?
SBC.
This is SBC.
Withdrawal of suit, liberty to institute fresh suit when not required to be specifically sought from court. Application for withdrawal of first suit filed after filing second suit. Withdrawal allowed on payment of cost to opposite party. Held High Court was wrong in dismissing second suit on the ground that it was hit by Order 23 Rule 1(3)(b) merely because specific permission to file second suit was not obtained.
So second suit is maintainable. That is what I told.
You will not be wrong. Did we say you will be wrong? No.
Yes, Mr. Mukherjee, then I can dispose it of right now.
Lordship, may I?
What may I?
This you don't give.
Already you go through that. Please give a reply on that. Yes. This judgment, Mr. Mukherjee, has been relied or referred to anywhere? Or this is the only judgment?
That's the only judgment as we find, Lord, but we have to check, Lord, with reference to the cause title that whether it has been relied upon subsequent.
Yes, because I had a faint recollection that it is Justice Sinha has delivered this judgment. But citation, I've forgotten the citation. What is the, देखिए आगे रही 40 ফাইলটা দিন একটু Yes, please give me the citation.
2008, volume 5, SCC 58.
2008, 5 SCC
Page 58.
58. What is the relevant paragraph?
Relevant paragraph would be 17.
17.
17 and 18.
17 and 18.
Item number 41 টা দিয়েছেন তো? 40. দেখুন 40
No, it's 17, 16 and 17.
16 and 17. Please go through that, then I'm taking up. Eta password করে রাখুন করে দিন. Yes, call the next matter. কি অর্ডার দেওয়া আছে কালকে মোশন Mr. Mukherjee, you have gone through that. Please go through that.
Tomorrow, Lords.
ঠিক আছে, tomorrow-ই রাখুন.
Lord, to be mentioned, Lordship,
To be mentioned, তাই করে দিন একদম উপরে ফরওয়ার্ড নো কেভিয়েট তাহলে ঠিক আছে ফরওয়ার্ড কালকে রেখে দিন উপরে Yes, next.
Appear for the opposite part.
Yes.
In this suit, I am for the plaintiff. If the defendant has taken on application for rejection of my plaint under Section 5 and Section 8 of the Arbitration Act. Now, when the
for the plaintiff,
I am for the plaintiff.
Yes.
There, I am the owner of the property. There was a development agreement.
What happened to 5-8?
During the course of the hearing, Lordship, I filed an application for amendment of the plaint. Now, the learned trial court has kept my application in abeyance, saying that first I will dispose of Section 5 and Section 8 application, and then I will consider your Order 6-17. Once if Order 5, Section 5 and 8 is disposed of, what remains with 6-17 here in the title suit, Lordship? But I don't understand. This is number one. Number two, Lordship, this amendment have got impact and bearing in my plaint, because what I have claimed, and in fact, if you Lordship may kindly see my plaint, it appears on page 148, volume 2. I have taken the ground of the fraud committed by the developer in the development agreement as well as power attorney. That was my prayer. Now
that was the previous view. Fraud, yes, civil court. Now the issue of fraud, the arbitrator can also decide.
Can also decide. But there are also judgment, Lordship, in such type of cases.
Now there was now it's settled.
Lordship,
it's settled.
Lordship, what I submit, Lordship, my amendment, now it shows that the fraud which I have pleaded in my plaint, it is more than that, because now we have came to got hold of some certain documents that the people who have signed on the registered power, he is a Bangladeshi national, he died way back, somebody impersonated, we have got hold all of those documents, Lordship. We have come with those amendment application in my plaint also, Lordship. What I was praying, Lordship, let my amendment be heard first, then if the court feels
that no, it was sent to the arbitrator.
Mr. Mukherjee, only one thing.
Lordship.
Going by the logic of Order 6, Rule 17 and Order 7, Rule 11.
But I would have certainly not abided by that because that is now the settled law. But it is not the case here because the court is in the midst of hearing my Section 5 and 8 application. When they took out an application for amendment of the plaint, the amendment of the plaint has got no nexus with the 5 and 8. If the 5 and 8 is allowed, only the court relegates the parties the arbitral forum.
No,
They are
but,
free to take the
yes,
point.
But if by allowing Order 6, Rule 17, the consequence might be your 5-8 has to be rejected. If that is so, why should not the Order 6, Rule 17 be hard?
I'll tell you, Lordship, because they have already availed of the written objection to the 5 and 8 application. They have never taken this point about the non-arbitrability of the procedure.
Subsequently,
this was
sorry.
No,
I'm sorry.
This was not the issue at all. And the learned judge in the impugned order said that I have already heard the application. Therefore, I'll continue hearing with the Section 8 application and thereafter I'll take up Order 6, Rule 70. It is not even closed.
Lordship.
Your Lordship will kindly have a look into the impugned order.
But only I was thinking...
If that was the logic, that Order 7, Rule 11, to obviate the risk of rejection, there is a necessity of an amendment, I would have certainly
If by amendment, if the amendment is allowed and thereby the suit cannot be, let us suppose if that is the case, cannot be referred to arbitration. So why not the Order 6, Rule 17
They are
to be
free
hard?
to take a supplementary, in the written objection to the application, but that is in the midst of hearing. But the learned judge has recorded.
Even if, let us think, because I am thinking of that line of judgments, Order 7, Rule 11 hearing started, but Order 6, Rule 17 has been filed. So the law is Order 6, Rule 17 is to be taken up. If
Let
the
us assume.
defect can be cured.
Let us assume, his application is allowed and the plaint is amended. But that doesn't cure, whether the matter goes before the arbitrator or not.
Yes. So after amendment, if this is taken up, what will be the harm?
It is because my application was for relegating before the arbitral forum.
Yes.
That is underway. Therefore, when the learned judge says that I have already heard it in part, that is what's the finding?
Learned judge says that
about this application was heard in part.
No, Lordship, can you see the
Please
impugned
show
order?
me the plain. Please show me the amendment application.
Yes, that is.
Lordship, amendment is on page 185. And the
What is 185 is?
My amendment application.
No, plain first.
Plaint is, Lordship, on page 148. And Lordship, we kindly see
148.
volume 2, Lordship. I'm so sorry, Lordship. There are two, it's a voluminous document, Lordship.
140.
And Lordship, may kindly see my pleading on paragraph 32.
What is the dispute?
Development
is
dispute.
that
Development
of power of attorney.
what he has done, there are several owners, there are several shareholders of the property. Lordship, you can see paragraph 32 of my pleadings, Lordship. 168 is the relevant page 21 of the plaint, Lordship. We have taken this point of fraud. And my prayer is prayer B.
Where is the pleading of fraud in plaint?
Paragraph 32.
Paragraph
32. Is page 167.
167.
Last 9 lines, Lordship.
Where is the
prayer is B, page 177. Now, Lordship, may kindly see my amendment application, page 185. In fact, the schedule of the proposed amendment is page 187. Now, see how the serious fraud has been committed.
So one thing you wanted to clarify or add certain things with regard to the allegation of fraud by way of amendment.
No, these facts were not there in my pleadings. These facts subsequently.
Yes, yes, these facts were not there, but the basis of there was a fraud that was there. So if that is there, what is the difficulty in 5 and 8 to be hard fast?
What I suggest, Lordship. Now, see the impute note of what the trial court says that first I will consider it, then I will consider order 6 rule 17.
Yes. Yes.
Lordship, there are subject to Lordship approval. What I have also made a such research, there are judgments where there are certain disputes, even on fraud, are non-arbitrable, Lordship. And these disputes are not a very dispute which can be taken into consideration by the arbitrator. It has to be decided in the time of the trial testimony. There has to be some evidence here.
Development agreement, why it's not arbitrable?
It's not arbitrable because there has to be an evidence, because what they have done, they have produced somebody who has impersonated to a Bangladeshi national who died in way back in 1992.
Mr. Mukherjee, can this dispute be because by way of amendment he has sought to incorporate the facts
And
which
we have got
touches
lot of
upon the
documents also, Lordship.
execution of this
Your Lordship will kindly similar the relief that has been prayed in the plaint, whether not those relief can be granted by the arbitrator or not. Lord, if those classes of Lord the judgments, your Lordship knows Lord Booz Allen and Vida Drolia, where it says Lord which can go before the arbitrator and which cannot.
unless it's a case of deadwood.
Yes,
Then-
basically, Lord, if the statute says that it should be decided by a forum prescribed, it goes to that forum. So here the prayer that my learned friend has made is essentially on Lord the propriety of the development agreement and the power of attorney. If their contention is that it was not correctly executed, it was done on impersonation, one is a criminal proceeding that they allege or a criminal conduct. And Lord, about the civility of that document, Lord, that can well be decided by the arbitrator. That apart, Lord, this question, what my learned friend now poses before your Lordship, he can also take this before the court, Lord, in support of his Lord, written objection that you cannot send it for an arbitral tribunal because this involves this type of questions. So, Lord, that has not even closed as of now because the order that has been passed is Lord, only Lord, which will be taken first. The learned judge is of the opinion this application is heard in part. Therefore, I hear the part heard application first. Either the matter goes before the arbitrator or it remains with the court. If it remains with the court, Order 6, Rule 17 will certainly have to be heard out. If it goes before the arbitrator, they will file the statement of claim, incorporating whatever they want to incorporate. Therefore, they are not absolutely not ousted from their contention to be brought on record before any of the adjudicating authority.
What is the position now with regard to fraud? What type of fraud? Previously, it was said that if it is an allegation of fraud, civil court, not the arbitrator. But the recent view is that no.
But even that can be decided by an
also
arbitrator.
decide the issue of fraud.
But the fraud is a very generic word, I tell you, Lord.
Here it's a case of impersonation, dead persons, names have been included.
And foreign
Whether
national.
this type, foreign national, whether this type also can be
But they're
decided
free
by
to
the
take this before the trial court, Lord, as a point. They're free to take this. The learned judge has not yet completed Lord, hearing of it.
Unless and it is
Therefore, the
amended.
question is before your Lordship is
Only
which one should
thing,
come first.
they cannot take this plea because the plaint does not contain this.
No,
This is
even
an
without
amendment
Lord, the
application.
point not taken in the plaint, Lord, about Lord, that whether Lord, the arbitration, arbitrability of the dispute, Lord, they can certainly take. Para 32 contains, Lord, some allegation of fraud.
Yes.
Some
but,
allegation.
That is some allegation of fraud and the details allegation of fraud.
Lordship.
If these are taken into consideration, is it not the court would not be in a better position to decide with regard to the arbitrability?
Let them take out a supplementary written objection to the 5 and 8.
Not in the pleading, Lordship.
No, it is not dependent on the pleading. 5 and 8 is an independent application.
But 5 and 8, Mr. Mukherjee, what's while deciding 5 and 8, what is decided?
Either
unless the arbitration, the agreement, which is the subject matter of the dispute, that will be considered, whether it contains an arbitration clause and what is the dispute between the parties. Now the suit. So the plaint as it is will be considered. Maybe you take many points, you say some points in the application, they take some points in the written objection, but basically this plaint allegation and the nature of the agreement and the clause, these three things are to be taken into consideration. Unless this plaint is amended by incorporating this allegations, whether even if he is allowed to take that point in the written objection, can the court look into that? Because will be that yes, in the plaint there is not such allegation.
But your lordship knows that there are certain classes of judgment which Lord decides on the point. There are many cases where Lord the execution of Lord the agreement which contains the arbitration clause is disputed. So in those cases, here my learned friend says it is an outcome of fraud, meaning thereby he says that there is no arbitration agreement.
Yes.
Even that be the contention of my learned friend in simplistic term. Lord, it can go before the arbitrator, Lord, and arbitrator has to decide that point under section 16.
Yes, now the recent view is that
it has to be decided about in section 16.
Arbitrator
Because
can also
his basic
decide and
point
say
is,
no.
His basic point
it
is
cannot
that there
be
is no
decided,
agreement.
it requires a full-fledged because these were the arguments when the previous view was there that it cannot be, this issue of fraud cannot be decided by the arbitrator. These were the arguments that yes, full-fledged trial on evidence. But now the recent view is that yes, the arbitrator can decide all this.
But Lordship, the thing is the people who have signed the agreement which concerns arbitration clause is not the same person. They are all impersonated Bangladeshi people. They have impersonated. So that agreement itself, whether it has got how far it has been legally valid or not, that has to be taken into consideration.
Mr. Mukherjee, are you carrying those line of decisions?
I can bring tomorrow, Lord. Tomorrow I can, Lord, assist your lordship by bringing those judgment where, Lord, how far of the fraud allegation can be decided by the arbitrator. But here, Lord, the question about not about the fraud, the quality of the fraud, but about, Lord, his question is whether there is a valid arbitration agreement or not. On the pretext that
yes,
it was not signed by a person.
Agreement, if this issue of fraud goes to the root of that execution, then whether it can be said whether that.
But he is seeking for a declaration about the authenticity of those two documents. He says that these two documents were not executed because some person, he had died and he was a Bangladeshi national. Therefore, he in substance says that there is no arbitration agreement to be referred to. Whether it is an outcome of fraud or it is a misrepresentation or it is by non-est factum, whatever the species of it. Kindly have a look into the declaration that he has asked for.
Only thing which I was only praying that let it be amended, let the trial court then decide on all these issue, whatever Mr.
Trial court is not deciding on the quality of the allegation.
Mr. Mukherjee, what Mr. Mukherjee is emphasizing upon, that whether it can be arbitrable, non-arbitrable, they can also argue there. The issue has not been closed there. I will amend my plaint, I will come with my objection, then let the trial court then decide it whether at all my plaint will exist or it will go away.
No, plaint doesn't go away. If Section 8 is allowed, it is the Supreme Court now has said that it remains, it is kept in abeyance till it is decided by the arbitrator.
Regarding the judgment, Lordship, Mr. Drolia, paragraph 36, I'm sorry, I've not got the judgment, but paragraph 36, the Honorable Supreme Court has categorically stated, when there are allegations of serious fraud, it is not arbitrable. Paragraph 36. If I'm subject to...
No, but
where is that judgment? You are carrying that judgment.
With that role, yeah, I can get it. With that role, আছে আমার কাছে কিন্তু
I can come back tomorrow, Lordship, if so pleases, I can bring those judgment answers.
Because unless he finds that prima facie no valid arbitration agreement exists. So here the question of the allegation of fraud, what is the
Lord, here what they say, your lordship will kindly have a look into Lord the prayers first, because Lord, what we see is that what is Lord the relief that they are asking for, either before the civil court or before Lord the arbitral tribunal. Now, Lord, the question here is they are talking about Lord the execution of Lord a degree for declaration that the said to deeds, one unregistered development agreement dated 2006 and registered general power of attorney dated 2012. Such and such, respectively executed, is not binding upon the plaintiff, and since same has been obtained by fraud and impersonation as well as by showing some proxy person in place of dead person. That is executed number 27 and 32 of general power of attorney, including all acts done by the defendant number 1 and 2 showing the said development
so the
agreement.
basis is
So
there.
this is Lord what that they have already prayed for. Now on the basis of Lord what that they have stated, Lord, I have taken out
So
the
this,
application.
this is already there in
It
the
is already there. The learned judge said that I will
So
decide.
dummy persons, dead persons, that is already there. But
That was only dead person. But here what happens, this is another person. There are several defendants. He was a Bangladeshi national. He never came to India. We had got hold of another suit, title suit document, where it transpires that he is a deceased person. Now, after 10 years of that deceased person, this developer, what he has done, he has gone for the commission. He got it registered. The
so
CV
Mukherjee, there is no decision on this. If Section 5 and 8 application filed and Order 6 Rule 17 of the plain, which one to be
I
decided
could not
first?
Lord, lay my hands on this
I
proposition.
also tried, Lordship.
I could not lay my hands.
Order 711, there is a decision.
Order 7 Rule, Order 6 Rule 17.
That is there, Lord, of we know of this court also.
Yes, but analogy might be the same, Mr. Mukherjee.
But here, why I say this, Lord, the analogy should not be
Because
imported.
both is rejection of plaintiffs.
Much more, Lord, of a higher Lord, degree. If your Lordship do not look into Order 7, Rule 12.
Yes, but
no, but this is
here, Lord, the question is all about, Lord, that whether there is an arbitration agreement and whether, Lord, it can be relegated, Lord, in the tested in the light of Buzalen and Vidato.
yes, if by this amendment, there are two things. What is troubling me is that plaint as it is and the plaint after amendment, would there be any difference so far as Section 5 and 8 is concerned?
Because Lord, the prayer
in the
remains.
facts of this case,
The prayer remains. The substance of the prayer remains.
prayer might remain. Mr. Mukherjee, please take a case because it says one line averment in the plaint saying, yes, there is no valid arbitration agreement. It was vitiated by fraud, such and such, such and such. You do not specify anything. And in the prayer also you say. So that might not, because in terms of the recent view, yes, it has to go because you are not specifying. But once you take out an application under Order 6, Rule 17, give specific particulars, specific details of those fraud. And if it is such a case, whether it can be relegated to the arbitrator or considering the nature of the fraud alleged, whether it should be decided by the civil court.
But that is not for the learned judge to decide on the Section 8 application, whether it should go or it should remain.
Yes, but two things. For the present, while deciding 5-8, the court will be concerned only with the plaint as it is.
The court is concerned about two things.
Consideration the amendment sought for.
Court is generally concerned about two things, about not the arbitration agreement, what is there, and whether not the prayers can be not decided by an arbitrator or not.
Prayers are nothing but
Not
what follows
these
from
are.
the pleadings. Pleadings is the ultimate thing, Mr. Mukherjee, because
the prayers are before your lordship. If the prayers are there, and Lord, if my learned friend tries to elaborate on Lord the process of fraud, Lord, it is neither here nor there. Because Lord, in substance, they say that there has been a fraud, and whether Lord, because of that fraud, whether the documents can be sustained or not. Now the question here is whether the arbitrator can decide.
This line,
I will. By tomorrow I can come. whether my lord the learned arbitrator or my
also
lord the learned.
please, on the issue of fraud also. To what extent it can be relegated, to what extent it cannot be.
Because here, my lord, the element of fraud that they are saying about the execution of the document itself.
So that
he
is
is asking
8 says, unless this expression is most important, unless prima facie no valid, unless it finds that prima facie no valid arbitration agreement exists.
That is the reason I say.
If fraud goes to the execution of the agreement itself, then it is prima facie no valid arbitration.
Absolutely. But this is from Lord the Section 8. When the learned judge is hearing the Section 8, this should not consider.
Yes.
And for that, he has enough material pleaded by my learned friend in the plaint. I've read, my lord, the prayers. So now that he is wanting to, my lord, elaborate is what his contention by a better particulars or whatever subsequent event that he came to know. Now, my lord, that doesn't alter the entire nature of, my lord, what he has, my lord, asked for. So, my lord, with that in place, the learned just says, no, let me hear the Section 8 application first.
When do you want? Tomorrow, day after?
Tomorrow, as your lordship pleases.
Day after the matter is fixed, your lordship. And one thing about what Mr. Mukherjee is saying, lordship, subject to Mr.
What? Day after tomorrow will be better.
One thing is, I've also taken additional point. The registration has been done, the registration of Assurance Authority. This was done on the basis of a commission in the different places of West Bengal. He has also committed perjury with the government authority also. It's not only simplicity or a private contract dispute with the parties.
That's a criminal element.
The government is also involved there. They have been also deceived by such an activity of having.
Heard the learned.
Morning I mentioned item number 55. Milord asking me to mention at 3:30.
47 I have reached. 55 I might reach.
No, this is the monthly list. Mine is the daily list 55.
Oh, yours is daily list. 3:30, both parties are there. Then, which Mr. Chatterjee?
Yes, left.
Might have fled when since Mr. Dotto has entered, Mr. Chatterjee will not come. When had I fixed that matter? What is the item? Item number. Mr. Dotto. তাহলে ওই যে ম্যাটারটা না তাহলে yes, call the next matter.
Can we come back?
Tomorrow. 47 টা ডেকে দিন, 50 পর্যন্ত ডেকে দিন, তারপর দেখছি। 47 কে আছে? Pass over. Next. 48. হয়ে গেছে? Yes.
There is no caveat, my lord.
Yes, what is this matter?
But I am seeking, my lord, for a short direction, my lord, for the appeal court under the PP Act to dispose of the appeal. Because my lord, mechanically, my lord, an order of stay has been passed and it is being continued for 1.5 years.
You want the stay application to be decided or the appeal to be disposed?
Entire appeal, because the statute provides 1 month from the date of filing.
Statute provides, yes, but
Kindly have a look to my lord, the order dated 29th
appeal
of
is
Jan-
ready. Appeal is otherwise ready.
No, what happened is, my lord, thereafter, my lord, in all dates, my lord, time is paid, time is granted. But
No,
kindly see
appeal is
that
otherwise ready.
otherwise ready. Now, my lord, please take, my lord, order number 329.
One thing, Mr. Dotto, what do you say with regard to the stay? Will you be contesting with the stay because affidavit files one for extension of the interim order?
Yes, interim order is continuing. Now, interim order is granted unconditionally, and recording that, the learned judge is not going into the merits of the matter, yet stay.
No, but do you want to contest the stay application?
No, I want the entire appeal to be disposed of.
Then the stay application has to be disposed of. Shall I record stay application disposed of as it is?
No, because we'll kindly see, my lord, under the orders of the estate officer, 10 crores is rental due, 26 crore is damages.
Then, Mr. Dotto, the stay application, I shall have to direct the stay application to be first disposed of. Or if you say no, you will not be, then stay application, stay order has to be extended. I can direct the appeal to be decided.
My lord, your lordship may kindly have a look to, my lord, the section 9. They have a copy there.
Section
9 of the, my lord, Act.
Yes, section 9 fixes a time limit.
Yes.
Mr. Dotto, only one thing. But the interlocutory application has to be hard fast.
No, definitely. But
So-
there has to be some condition. Kindly have a look to this.
এই কোথায় গেল পিপি একটা কোথায় ও আছে
Kindly see, my lord, section 9, subsection 3. Where an appeal is preferred from an order of the estate officer, the appellate officer may stay the enforcement of that order for such period and on such conditions.
Yes. Then according to you, an unconditional order of stay could not have been passed.
Yes.
So then the stay application has to be decided fast.
Yes.
So I can direct the stay. Or if you say no, you will not be contesting with the stay, only appeal, then the stay, I can direct this. That stay should continue till the disposal. I direct that disposal of the appeal.
No, but
Without
impose some condition.
that expertise cannot be done. Then I do one thing. I direct the stay application to be decided within a time limit. You raise all your points there.
Well, within in that case, we direct Miller disposal by 15 days. Because the entire appeal is
Stay application. What is the next date fixed?
First of September.
You have filed your written objection.
Stay filed.
Stay
objection filed.
Stay objection has been filed.
Yes, we have filed a vacating also. I stand corrected. Plus, we have filed a vacating.
Yes, stay application they have filed. To that,
I have filed my objection
as well as the vacating. So, along with the applications filed by the respondents dated 7/8/2025 and 23/4/2026. What are these two applications?
7/8 is my vacating.
Vacating.
Yes.
And 23/4/2026 is occupation charges might be. Please check up. All right, I direct these two applications to be decided first, then to decide the.
Keeping in mind, Miller 9(3) conditions.
Yes, you raise all points there.
But kindly, Miller, please consider mentioning it in your lordship's order. Because the stay has been granted, saying that I do not go into the merits of the matter, stay. Of the matter, rather just to give a window to the respondent to file their objection. Thereafter extensions.
The order dated 29th of January 2025 We mentioned, so only one thing, Mr. Dotto, please ask your junior to inform Mr. Chatterjee, because if he writes the letter to the other side, and it is because I'm recalling, then the learned advocate might be in difficulty. Please tell him that not to write any letters.
But I faced this.
That is why, because I have passed an order. Now, since if that is communicated and thereafter this is done, he might be in some problem. Please tell him. Yes, next.
This is my application, my lord. My lord, I challenge the inquiry report passed by the Internal Complaints Committee under the POSH Act. My lord, kindly takes the POSH Act of the aggregation. My lord, 4 provisions of the POSH Act, my lord, I need to place before my lord, I take through my lord through the nuances of.
What is the urgency, Mr.
Lord, today is the 30th day of my waiting period. Today I'll be, my lord, thrown out.
You have been thrown out inside.
My lord, I have been found guilty under the POSH Act on the basis of a complaint made by a male employee. Male employee lodges a complaint under the POSH Act. I have been, my lord, found guilty. My lord, orders passed. Today is the 30th day. After 38 days, my lord, kindly seize this. 30 days waiting period ends today. 30 days waiting period ends today.
Do mention it?
Please, my lord, your 30-day waiting period ends today. This letter was given on the 11th, my lord, saying that 23rd day is 11th. So today is the 30th day, my lord.
No, 30th day, where is?
Please, my lord, 23rd waiting period day on 11th of.
Please find it, the intimation for 23 days business wait.
Yes, business wait is till 30 days. Thereafter, I'm thrown out. So, my lord, on 11th, it was 23 days, my lord. So, 18th, my lord, today is 30 days. My lord, the irony is, my lord, complaint admittedly filed by a male employee. Kindly, my lord, takes the act, 4 sections, my lord, of the act. Section 9 of the.
What is the impugned order?
My lord, the impugned order is appearing, my lord, at page 187. This is the POSH inquiry report.
Yes, inquiry report. Thereafter, it has to be sent to the disciplinary authority.
No, it has to be appealed against. 189. Kindly seize page 199 as well.
No, where is the inquiry report? Please show me that.
That's at page 187, my lord.
Yes, where is the concluding part?
The concluding part would be, my lord, at page. My lord, page 20. It would be 192. Most importantly is point 2, final recommendation. Seize point 2. It's a demotion. Thakko's role be changed to that of an individual contributor not supervising others, especially junior employees. So it's a demotion, my lord.
Yes, after this recommendation, what happened?
So, my lord, after this, kindly takes up page 199.
Yes.
disciplinary action has been taken against you due to breach of disciplinary policy of the company. Such and such reported date serves as a formal warning in connection. So, my lord, what is happening is, my lord, I will be suffering a demotion.
But
My lord, 4 sections of the POSH Act. Then, my lord, kindly seize the supplementary. My lord, there's a supplementary affidavit which we intend to file for a subsequent event. my lord.
proceedings,
Kindly seize.
can you directly challenge in 227?
Yes, because that's the reason I said, my lord, 4 sections of the POSH Act. My lord, kindly first takes up section 4. My lord, I handed over, my lord, a supplementary affidavit.
Yes, this is a supplementary affidavit.
Kindly seize page 7. What I am also agreed by page 7.
This is post.
Hello, Shakho. In line with our discussion today, there is no IC role available at your position within bond. I request you that over next 30 days, you consider other employment opportunities within Tech Mahindra outside of bond. Similar. So this is what is also I'm agreed by. Now, Mulad, kindly POSH Act দিয়েছিস? থাকলে আর দিয়ে দেন।
Yes.
Mulad, first, Mulad, kindly seize section 4(2).
Yes.
The internal committees shall consist of the following members to be nominated by the employer, namely, kindly comes to B, not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. 1 member from amongst non-government organizations or associations committed to the cause of women or a person familiar with the issues relating to sexual harassment. So, minimum 3 members has to be there. Minimum number of members. Then, Mulad, kindly comes to section 9. Any aggrieved woman may make in writing a complaint. So the complaint has to be at the instance of woman. Complainant must be a woman. And that is what it should be. Now, Mulad, section, Mulad, then section, section 11(3). For the purpose of making an inquiry under subsection 1, the internal committee of the civil court.
Yes.
Civil jurisdiction of civil court.
No, this is the that procedures shall have the same power with regard to this.
Strappings.
Yes.
Then Mulad kindly takes the provision of appeal at page 18. So there's a provision of appeal. But I say, Mulad, when the complaint is stillborn and the authority which determines or adjudicates, Mulad, the complaint, if that suffers from an error of composition, Mulad, 227 is attracted. Mulad, I showed, Mulad, minimum 3 members. I showed complaint by a woman.
Please show me where is
kindly seize, Mulad, the report.
Complaint. Where is
Mulad, page 187? Kindly seize the report.
187.
Kindly seize, Mulad, date of complaint.
Yes, 16th.
Date of incident, then seize, Mulad. Presiding officer and 1 IC member. The other one is a coordinator.
Yes.
Then, Mulad, complainant details.
Yes.
Kindly marks employee name, Mark Aladis. Gentleman making an application, a complaint under the Act.
Sitting in New Zealand.
Sitting in New Zealand, that I'll show. And he also says that he was not in the. I'll also show. Kindly seize, Mulad, the communication of the complaint at page 28 by the company to me. Merely because woman contains man, that doesn't mean a man can make a complaint. WMN contains man, doesn't mean a man can go and make a complaint.
Uh,
Passover matter on item number 39 of the combined list.
Passover item number
39 of the combined list, my lord.
39. 39 টা বার করতে পারবেন দেখুন। What is that?
Here, my lord.
Yes, what do you want?
My lord, here, my lord, a joint petition, na? Matrimonial suit, my lord, under section 13B of the Hindu Marriage Act was filed by the spouse, my lord. Now, my lord, what happened, my lord, during pendency of the matrimonial proceedings, my lord, matter was referred to, my lord, for mediation, for settlement, and an agreement was arrived, my lord. Pursuant to that settlement, my lord, and order was passed by the learned court, my lord, disposing the matrimonial suit, my lord. But my lord, decree was not drawn up, my lord. In the meantime, my lord, the husband of the husband was died, my lord. Now, my lord, father of the husband, my lord, now came up before the court, my lord, with a petition under section 151 of the Code of Civil Procedure for drawing up the decree, my lord. And my lord, learned court passed the order, my lord.
Yes, who are you?
I am the wife, my lord.
Yes. So the decree was passed on consent. How are you aggrieved?
My lord, decree was
The decree is drawn up.
My lord, decree was not passed. My lord, order was
He was passed. Drawing up, it's a ministerial job. Ashun. Call the next matter. Rakun.
The plaintiff petitioner before Lordship, my lord. Plaintiff filed a suit, my lord, for recovery of damages, my lord. What happened, my lord? The plaintiff and the defendant, my lord, have a leave and licensing agreement for my lord.
What is the impugned order?
My lord, 20th April 2026. An application under section order 26 rule 9 was filed by me, my lord. That was, my lord, rejected. What happened, my lord? There is a leave and licensing.
Order 26 rule 9.
Yes, sir.
Why?
Because, my lord,
What is the suit for?
Suit for recovery of damages, my lord.
Yes.
A suit, a student was running on the, my lord, in the, my lord, in the property of the defendant, my lord. My lord, suddenly when it was running in the full swing, my lord, one day, my lord, on 26/6/2024, the defendants and the agents came, and my lord, they have, my lord, they have they have, my lord, kicked out my employees, and thereafter, my lord, put a padlock on the restaurant, my lord. Everything was there, my lord. All fixtures, my lord, all things was there, my lord, in the restaurant, my lord. Thereafter, we filed a suit for damages because I have, my lord, I have expensed much for making this as a restaurant.
Where is your application under Order 2609?
My application, my lord, kindly come to page. After the, my lord, order of the injunction, my lord. Last, next one. Order 26 rule line, my lord has got. After 62, there is the order of injunction thereafter, my lord. Last, next one. And thereafter, my lord, they have put a padlock and everything is there in that room, my lord. There is, I filed a suit, status order was passed, and my lord, what I am on, my lord, there is lots of things, my lord. I have, my lord, stated in my lord, Schedule B, my lord. There are lots of things, the articles and everything of a restaurant, my lord, is there. In Schedule B, my lord, I have stated. And that is in a damaged condition. They anytime, my lord, they can, my lord, remove those, and because the padlock is put by the defendant, my lord. That is why I want to see, my lord, I want, my lord, the commissioner to, my lord, see what is there or not, and that is why, my lord, I filed this application, my lord. And that was rejected. Though, my lord, status orders passed by the learned judge. Only for that reason, my lord, I filed that. Those articles so is there in the restaurant that was suddenly given padlock by the defendant.
The property is still under lock and key.
Yes, ma'am.
Where have you stated that?
In the
According to you, they have taken possession.
yes.
And they are running the business.
No, my lord. That is in that is
By the order impugned.